Well, subject to your losses.
There is some good news for we thought that we will share with the members of the bar and other stakeholders. We are launching some new initiatives to harness information technology as device to reduce case pendency and to enhance operational efficiency and transparency. So, 2-3 things today are being launched. One is a very significant step forward in case management, where we are introducing a digital partnership with the various high courts through the creation of a dedicated online platform. This platform will enable detection of cases that have become infectious due to any change in situation of the litigation in high courts or even in the trial court. This platform will also enable swift reportage about instances where proceedings in the high court are awaiting adjudication by the Supreme Court, and therefore remedial measures can be explored in such cases where all proceedings in trial court or in the high courts get stayed because of the pendency of a matter here. And this portal will also function as a repository of crucial case information in respect of matters pending in two major tiers of our judicial system, High Court and Supreme Court, strengthening our reciprocal commitment towards effective litigation management and reduction of case pendency. The second app or the facility which we are launching today is going live with the integrated online payment system. We have named it IOPS, intended to consolidate and streamline. This is important for the members of the bar. So this pertains to payment processes related to administrative services utilized by lawyers, citizens and Supreme Court employees, such as payment for AOR examination, AOR exam fee, then examination registration fee, cash facilities and several other services. Now this IOPS shall simplify the process of these payments, ensuring greater transparency at every stage. We are also revamping the third important aspect in our opinion is very, very important, is revamping of our security in the Supreme Court campus, automating the management of vehicle permissions. This will be done through a secure platform, and we have named that platform as PARK, means Parking Authorization Record Keeper. So the applications can be submitted and processed online, supported by automated verification checks and the reduction of reliance on paper and manual data management. Applicants can track the status of their applications at every stage and access through a dashboard notice issued by the security branch concerning any violation. This is quite critical importance of the matter is because overall safety and security of the court, the lawyers, the litigants and everyone. So therefore, we really consider it as one of the administrative milestones. It's a very progressive approach and it will facilitate the parking and the security both. So we are hopeful that members of the bar, litigants and all stakeholders, they get benefit of this facility, and these help our registry also in operational efficiency.
Malad, subject to your lordship's kind permission, I am mentioning under compelling circumstances. Despite the 3 occasions this honorable court has passed this order, the matter will be reached at the top of the board. The people has come from Andaman Nicobar Islands, my lord. Matter is the Andaman Nicobar Islands. The people are coming yesterday also, but they are seeing the matter has not been listed. Lordship, can you see this order, matter? Any bench is not a partner matter or special bench matter. Matter could have been listed in any bench matter. But despite this order, matter has not been listed, matter. Can you see?
Well, what is the point with you? No, official visit. He is away to Philippines. The learned presiding judge is not here.
Honorable Justice Monmohan has said Honorable Justice Manoj Kumar Mishra in court number 13.
We can't shift the case like this.
No, any day, Lordship can fix, Any
If you
date,
can, if you want before some other bench, then you file an application.
or any, Dorothy, can you fix any date, Malad? I am,
No, no, we can't do it on oral mentioning. We, for the same bench, I can give a date.
Malad, your
For the same bench, if you want a date before the same bench, I can give you a date. But if you want to shift the
appear on same page, Malad, same page.
bench, give a date.
Can you 6th February, Lordship?
That is not a difficulty. That will give you just in 10 minutes.
Top of the board may be maintained, Malad.
That will be there. This can be done.
Right.
But I can't shift the matter from one bench to another. That is not appropriate.
Another mentioning matter subject to your Lordship's bench, Malad. Malad, remember the landmark decision made by this honorable court regarding setting aside the Tribunal Reforms Act 2021, by which all the present members of the Administrative Tribunal have become, in terms of this act,
Well, everything you are making orally, please mention some.
Malad, our bar decision has filed this matter.
File some matter.
Matter is coming on 22nd February.
Yeah.
I am only requesting people, Lordship, not to be deleted on that.
On second, it is coming.
My lords,
If it is coming, it will be taken up. You be ready.
Your Lordship, may I?
my lords,
leave back.
my lords, may I mention this item 42, 15, 40 and 41 before your lordships yesterday. This is the temple matter in which your lordships ordered mediation. My lords, I'm item 42, I'm the AOR. None of our senior council's names is reflected in the order. The order just came
How
out
can
today.
this mistake be?
And I filed detailed appearance online and physically, my lords.
No, there is no question. You don't require any proof. They have appeared before us.
Yes,
No by face.
yes.
They appeared before us. Why you are not mentioned? Huh?
I could supply a detailed list, my lord.
What online? For both sides you are here. I can right now tell you the names.
So obliged, my lord.
Our mistake.
I'm
Allowed to
deeply
rectify.
grateful. I'm so obliged. I'll give the full list.
Your Lordship, may I mention a
I'm so
leave granted matter? This concerns 39 daily wage employees who are directed to be absorbed as permanent.
ये दूसरा तरीका मेंशनिंग स्टार्ट होगी.
I'm-
हम कहीं से इसको बंद करते हैं फिर निकालते हैं.
I apologize.
What is that fine?
This concerns 39 daily wage employees and the matter is really important. And
Don't mention
application,
anything. We have already told you. Give everything just on a piece of paper, 1 page application, 2 page application. That's what we will examine it.
Lord, we had filed the application for mentioning, my lord. Somehow it has not been listed here.
Application for
Mentioning, my lord. It has been filed yesterday in time, my lord. It is not listed, my lord. The urgency is, my lord, Bar Council of Election, my lord, Bar Council of UP election.
Council election
30,
in Maharashtra
31st,
state election.
30, 31st are scheduled to be done on Prayagraj, my lord.
In the history of democracy of this country, only 2 elections we are seeing very closely. One, the Panchayat election in Maharashtra, we generate every day 10 to 15 repetition before us, and another is Bar Council.
Yes, my lord, I totally bow down to my lord. My lord, day before yesterday, we had to cancel Lucknow election because 27,000 people participated to vote. Tomorrow and day after tomorrow are the dates for Prayagraj and 31st is the cutoff date. But we are seeking extension of 2 days, my lord, 1st and 2nd February, so that in 4 days Prayagraj election could take place because there are 33,000 voters there, my lord. Yesterday's election
Very
was,
well. You, at least you are aware of your voter list.
yes, my lord.
You are also, one can legitimately expect that after all the voters are the persons belonging to legal fraternity. So they are expected to cast their vote.
Yes.
So they are conscious of their rights. It is their institution. They would like to participate. So if all arrangements.
But this hunch is because of this reason.
Uh,
This hunch, my lord, is for the reason, my lord. The Lucknow election held in the High Court premises. And that despite that, my lord, due to the security concern, they were cancelled by the High Powered Committee, my lord. So therefore, as a precaution, we are seeking 2 days extra time so that in 4 days' time, this election could take place in Prayagraj. So only 2 days, my lord,
What
I am
is
seeking.
that in the election there?
31st January was the cutoff date, my lord. All the elections at all other places have already taken place.
Only
Lucknow is cancelled, my lord. So the fresh date would be announced by the.
Just take all the oral mentioning, the application is taken on record, heard. The last date to conduct elections of the Bar Council of State of Uttar Pradesh is extended up to 2nd February 2026.
Grateful.
Up to 2nd February 2026. Tell you.
My lords, if
Briefly,
I
good.
mention a matter, I'm a YouTuber and an investigative journalist. My interim bail application was sought to be cancelled by the state. In that cancellation petition,
Interim bail sought to be cancelled.
in that petition, the High Court has imposed stringent conditions. I am being regularly harassed and brought into questioning by the authorities. There are multiple petitions and cases in which I was granted this interim.
So,
My lords, my petition will become infructuous on Monday because they're trying to monitor my medical records as well. I am under regular consultation. I'm a heart patient. I'm seeking to challenge those conditions because the court has ordered forming of a medical board.
कल लगाता हूँ.
Malas, this mention is with regard to chamber matter, Malas, which is listed today before Malas and companion judges at 1:30. Malas, as per the last order, we have filed the additional documents, Malas.
Let it be, like we are not concerned about.
Malas, only because the defense
Thank you very
has
much.
come
Thank you.
today.
Start the matter.
Malas, great.
Don't question me.
This is a recurring issue and it affects the entire pricing mechanism, my lords, of electricity. Because I am appearing for the distribution company, whatever is the earliest convenient date to your lordships, my lords, it may be fixed.
See, early hearing, don't give early hearing. We will pass some order in early hearing. We'll
Because this affects the entire system.
We'll examine.
Macho, macho.
Totally hearing, sir.
Yes, we go item 7.
No, item 7, my lords. No, I am hearing item 7. Eleven petition, my lords. Look, item 7, 4 has not been. It was item 7, my lords.
Notice.
It's a section 11 petition, my lords. It is.
7, we are not hearing in early hearing. ये रजिस्टर पब्लिश ये early hearing entertain के लिए बन
My lords.
Yes, please, item 8.
Yes, no, I'm appearing. Your lordships had flagged this issue in a judgment last year about the plight of domestic workers. This was your lordship's judgment in the context, minutes, of something else, but your lordships found it important enough to flag this issue. But minutes, right from 1959.
Ramcharan, you must have read that.
Yes,
You have seen that.
yes, sir.
See, we knew that to what extent we can go. Because ultimately, we didn't want to invite this criticism of overstepping, overreaching, going into interfering in the domain of the legislature, policy makers. So we flagged an issue, we left to them that you please take a call on it.
Now, my lords, your lordship's judgment was only the last in a series of efforts which have started from 1959. Attempts at legislation have started from 1959. We have set out that history. 2009, the then government Labour Ministry had constituted a task force. They recommended that this be included. Then, minutes, in spite of their recommendation and representations, state governments, 15 have done, others have not. 15 have done, others have not. Then, minutes, your lordship's judgment highlights the issue. I am putting it.
Oh, comes. Every household will be in litigation. You take it from us.
All of us, minutes, your lordships, in Asia itself, for instance, when it's 5 hours away from Singapore, you can't hire a domestic maid unless you register that person, weekly off, wages, etc.
See,
So many minutes.
Mr. Rajaramkan, who knows better than you, sometimes in our anxiety of reforms, in our anxiety to bring something, a non-discriminatory perspective through legislative means, we ultimately lead it leads unwittingly to a further exploitation. You fix a minimum wage, people will look at the need of employment in this country. It's a question of supply, demand and supply.
Lordship, please, Manoj.
Demand is less, far less as compared to the supply. The people available, unemployed, youth, unemployed, even senior citizens, children, people are being exploited like anything. You fix the minimum wage, people will refuse to hire, and this will further generate to their hardship.
On the other hand, Manoj, with respect, 15 states and 2 union territories have seen the logic. And they have included. And I am posing a constitutional question.
These are basically just to gain kind of popularity without realizing the real truth. We do not know how the people
It's
are
not
talking
popularity. These are-
without knowing the society.
These are all workers' unions. These are not some outsiders who are coming. These are domestic workers' unions registered under the Trade Unions Act. 10 unions. So these are not some strangers who are
They have
coming.
successfully, how many industry in this country successfully have been closed because of thanks to this trade union?
That's it.
Let us know the realities also. All traditional industry in this country, as child we used to see the industries all because of these Janda unions have been closed all throughout the country.
There are problems. There can be collective bargaining leads to
They don't want to work. These all trade union leaders, they are so largely responsible for regressive industrial stopping the industrialization growth in the country.
with utmost.
Of course, exploitation is there, undoubtedly, but the means should have been different to stop that exploitation. People should have been made more aware of their individual rights. People should have been made more skilled in their, instead of using them as manual labor. There could be several other reforms that should have been done.
With utmost respect, words. Let us not, with respect, generalize and talk of larger issues because collective bargaining is a valuable right. But today we are talking of the weakest
This
section.
class is no doubt
Talking
exploited one.
most exploited. I'm putting it on a constitutional principle, words. Lordship, please. Stop there.
Mr. Raju, please see your pleadings in paragraph 34. It's
Look.
not that there is no safety net. We understand what you are saying, that also ensure a better
Minimum wage.
equal treatment legal framework where work when obtained or made through domestic workers should be given same respect and economic value as that of industrial workers.
So,
But to talk and to say that they are left in the lurch, your pleading itself acknowledges that the Unorganized Workers Social Security Act takes care of the basic needs of medical health and other consequential benefits.
but that's why we have put it below, because there's nothing to be
Yes,
kept back.
And it's
Therefore, that's why we have put all this.
and even,
But, I'm
as
sorry.
you rightly said, that the Honorable Chief Justice's judgment in fact narrates the entire legal history.
Exactly.
The legislative history and repeated attempts. Please understand one thing. Courts are very apprehensive, if not timorous, when it comes to economic policies. And this creates an economic situation where until or unless we see a complete denial of Article 21,
Lordship, please.
we feel a bit hesitant. Your point is very well taken.
So let me therefore
One
attempt.
should be disrespected just because he is working, she is working as a domestic worker in relation to an industrial worker.
Let me attempt to furnish a constitutional basis and minutes without inviting the court, because very carefully, without making the court tread on territory which it should not tread upon. Being conscious of that, I am suggesting a constitutionally acceptable path for your lordship's consideration. It is this, Minister, and this is in the context of a minimum wage, which, if not paid, has been held by this honorable court to be begar.
Absolutely, no doubt about it.
21 and 23 are involved. So now the question is not of under inclusion, because constitutionally there are two different concepts. Under inclusion, the courts have always said no. The legislation may proceed in stages. It may choose to cover someone, it may not choose to cover someone else. That by itself is not unconstitutional. Your lordships have repeatedly held. But here the question is, if deliberate exclusion results in a violation of fundamental rights, and the most primary fundamental rights under 21 and 23, then by mere executive action, because the power to add to a schedule or subtract from a schedule is given ultimately to the administration. If it was a legislative policy, I can understand. But to add to or not add is given to the government. If that violates fundamental rights, then, the court would be within its province, I am respectfully submitting, to ask the states. After all, today, we are in a stage where they are asking for a declaration that non-payment of minimum wages amounts to a violation of 21 and 23, apart from 14 and 15, because women are the most affected.
Mr. Raju, declaration is only a lip service. The question will be how to enforce that.
Now, therefore, in the context of that declaration which I am asking, since all states have been made parties, and 15 states have found it fit and appropriate to give this protection, your lordships may at least hear from those states why they have not included. When the central task force, when the central government's task force, Labour Ministry tells all the states, please include, in spite of which, if they don't include, your lordships will at least first hear from them what the problem is about it, including wills. There, in my respectful submission, when the legislative policy is there, the framework is there, and there has been inclusion by different states and the central government, after all, it is basically a central law. When the central government's task force says, please include, then this amount of inquiry by this honorable court, today our lordship is not compelling any legislation. We are not at that stage at all. But to exclude this section at this minute is about 8 crores of people are excluded. Large number, ultimately, those who suffer are women. So 4 fundamental rights, 14, 15, 21 and 23. Can it all depend merely on the stroke?
It is very attractive, Mr. Raju, to argue that yes, Article 14 violated, 15 violated, 16 violated.
Not
all
16 minutes, not 16.
16 also. Yes, why not?
I won't say 16 at all, but
Also violated.
16. 21 and 23 minutes, 21. 23.
See the other consequences. Please examine those consequences. These trade union leaders, they will leave these people in lurch. People will refuse. People will stop hiring domestic helps. We already, you know what's happening. I think you must be also experiencing it in all major cities. These service provider agencies have already taken over everything. You now don't go for your drive to engage a driver. You don't go to engage your domestic help. You don't go to, you only use the services of these big entities. There is a word which I can use, but I don't want to use in open court for them, these entities. And what they are doing, they are exploiting these people. They are the real exploiters. I have personally, officially, I have seen it in one of the instances. I have dealt with this. The Supreme Court paying to an agency for hiring of a particular set of skilled employees, paying say rupees 40,000, and actually those poor girls getting only 19,000 from the agency.
Yes, it happens with our security guards, our domestic security guards. That's what happens, but
so more and more, the moment you break this trust between the domestic help and the family who is engaging them. There are millions and millions families who engage a domestic help, make him like a part of the extended family. They live in the same house, they stay with them, they eat the same food, they stay there together because that element of trust is there. If you start hiring them through these agencies, what will happen?
No, there's no question of
Senior
agency.
citizens are being harassed, suddenly you find a very heinous crime has been committed. Who has done it? Some domestic help hired through an agency. Because that human bondage, human relationship is conspicuously missing in that relation.
I would only request this honorable court, Millards, to consider these are not those huge big trade unions politically funded, etc., etc. This is not US type of collective bargaining, getting maximum from an employer. This is basic minimum wage, Millards. And as against most of us who pride ourselves on treating our domestic staff well, your lordships are equally conscious of the amount of exploitation which takes place.
Sir, you fix a minimum wage, I tell you, and I hope that you will also realize, these very so-called leaders will make sure that every household is dragged into litigation.
Millards,
Every household will be dragged.
Millards, why, if 15 states have seen the logic of it,
Why they are not
15 states,
Why have not then they come forward?
if 15 states
No,
have
but
seen
what
the logic
prevents
of
them?
including, I'm saying, then the question is why the remaining 15 have not?
No, question is that what prevents them from enacting the law? Why do they need, if they are realizing it, why do they need a Supreme Court direction?
Therefore, they need to come and explain to your lordships why they can't. If Millards, 15 states, if half
In other
the
words,
country,
Mr. Raju Ramchandran, in other words, we'll be asking them to explain why are you not enacting a law for which you have already made a commitment?
no, with respect, no. Not even enacting a law. The law is there. Why are you not exercising your notification extending power? The legal policy is there.
But
The
they don't
legal
want us
policy
to
is there. The nature of this employment is a well-known employment. Should all this depend upon the labor secretary of a particular state?
These
After
are-
all, the logic of what we are saying,
Eventually what you are arguing again leads to us to issue a direction in the arena of the legislative policy. You want us to directly either issue a notification or enact a law. That is what, without issuing that effective direction, nothing can be done.
if my prayers are seen, Millards, none of this is included in the prayers. If this honorable court in 1982 in Bandhua Mukti Morcha could say that it amounts to Begar, that declaration of fundamental right means something. All that I am asking is that today, 45 years after Millards Bandhua Mukti Morcha, or 43 years after, the condition of domestic workers in homes is such that a declaration of their legal rights ought to be made by this honorable court. How it gets translated into notifications, etc., is the next step where, of course, your lordships will proceed very cautiously with the aid of
Have been made also.
this with respect, Millards, can't be. If the consequence is Begar, then that can't be. That is my endeavor to show your lordships a constitutional path.
The code of wages also says 5 or more, then it comes within this.
How many people, Millards? Everybody is not an industrialist who has 5 domestic staff, Millards. Everybody.
That is
All of
the
us
reason-
are.
Mr. Ramchandran, perhaps that was going through the mind of the legislature to distinguish a profit-making or industrial activity, commercial activity, from a contract of personal service. When it comes to a contract of personal service, a special classification was made. So social security was advanced, but the requirement of minimum wages was not imposed. In certain states, it has been, as you rightly say.
If the lords,
All
is
your
not just-
prayers, all of your prayers directly, indirectly are legislative actions. If you come to page 71,
Lordship, please, Manoj, take out 71. Yes, Manoj. Yes, Manoj.
read prayer number A. Number one,
Any other appropriate declaring that domestic workers have a fundamental right to a minimum wage. This is not a new declaration, Millets. It has been made by your lordships in the past, as I said.
you are not wanting any empty formality, a decree which can't be executed. You want a decree which is worth execution. Now, if a decree and worth execution, if you read a prayer A with B, that's why prayer B. You want that why they have been excluded. It's not a question of exclusion. You want us to include them.
If your lordships hold,
Exclusion will be, Mr. Raju, that suppose in the original enactment of, let us say 2019, or when the minimum wages act was originally enacted, if the domestic workers were included in the schedule, and if by a subsequent amendment if they are excluded, understandable that why they have been excluded. You are using the word very intelligently drafted, no doubt we admire that drafting, but exclude.
younger colleagues, but there's no senior wisdom here.
No.
All credit to my younger
When the
colleagues.
young lawyers, they apply their mind a lot.
Yes.
They knew that inclusion will directly be asking the court to indulge in issuing a direction for legislative action. Instead, they say exclusion. There is no exclusion because there has never been an inclusion. So what will happen? Prayer B can only be when we direct the lawmaking authority that you please amend the schedule and include the domestic.
Therefore, my attempt is to show that if an exclusion is not merely a policy choice, but if an exclusion is unconstitutional because the failure to include this, a recognized employment, results in begar, and it is not just wage, Millets, a weekly off. How many domestic helps get a weekly off, Millets?
It would amount to begar only when the employment is a scheduled employment under the state.
Millets,
Until and unless it is a scheduled employment, payment in kind or by cash will not attract Article 23. It is begar when an activity which becomes regulated is in breach of the regulation. It not only breaches the statutory provision, it also has an impact on the fundamental right of the person.
with respect, that is a legal construct. That is a legal construct.
Sir,
But if
why we are saying it is, in this situation, when the legislature makes a decision to include or not to include, it goes by a classification. And you have every right to challenge the classification on the ground that the classification is irrational, has no object or nexus with the purpose that it seeks to achieve. In that situation, domestic workers being kept aside by certain states from being scheduled employment, definitely by the very nature of their personal service, is a peculiar class unique to themselves in comparison to industrial or commercial workers.
because every employment will be different from another employment.
Consider a similar legislation of employing children. There is a fundamental duty, past as well as directive principle, which is read under 21 capital A, not to employ children. Then, in spite of that, hazardous area, employment is a complete part. In certain areas, including agricultural work, employment is regulated. So, there are situations, as you are rightly saying, that when we are looking at human resources and the valuable human rights and fundamental rights of weaker and vulnerable sections of society, the state has approached it not always in an absolute sense or a categorical sense, but also with a sense of graded response. So this is a more a graded response.
Because my attempt so far has been, and I think it is a failure on my part, that I have not yet been able to persuade my lords to issue a notice to ask those states why they have not been able to do what other states with regard to the same kind of employment have found it fit to do. It is, on the one hand, is the fundamental rights, on the other hand are the directive principles, living wage, etc. This, in my respectful submission, calls for your lordships at least to find out why the character of domestic employment doesn't change from one state to another. Bills.
Any response received by you from the Union of India or from any state government?
Yes.
And all saying, Union of India says it is for the states. Union of India says it is for the states. We have said that in our petition.
For the state, and if you think that some of the states have already in principle taken a decision, then Mr. Raju go and approach the respective high courts. They will call for the state. They will find out that what are the difficulties, what are the impediments in forming a legislative policy on that issue.
Some states have not just in principle, but actually, but if I have not been able to persuade my lord so far, give me liberty minutes.
Where have you approached the states?
All the representations are here on record. All the representations are here on record.
Let us see any
Yes,
particular one.
not anyone.
P88. Volume 3? Yes. Volume 3.
Yes, so now you take it out.
Yeah.
Barring some resolutions where we have been able to lay hands,
Yes.
there is no formal representation to any
Page
state.
992 minutes.
Huh?
Page 992, for instance, is one representation.
Relations with states.
Up to 1075, 992 to 1075 are all representations by these unions to different states.
It is not for also to reach only 3 states to responded.
And I'll give you, lordships, one sample response. Because from 992 to 1075,
Where is the response?
yes,
by the
I'll give you, lordships, one sample response. I'll give you, lordships, one sample response. Just give.
One sample response you please give us.
Yes, please. I'll give you, lordships, in a minute, minutes.
One, my lord.
Yeah, give me the response itself.
So who's the union? The state. State is limited. Usually 8. P98.
Yes, page. Yes,
1077.
page 1077.
1077.
7. This is from Additional Commissioner of Labor, Telangana, to President of the
That is the
Telangana.
problem. These officers are at very small level because an additional labor commissioner is not an authority who can take a decision.
We wrote to the state pushes it there. That is the problem. We write to the state. For them, it is a minor matter, therefore it gets sent.
No, but this communication 1077,
Yes, Minister.
this labor commissioner invited you, this association, to talk.
Went and met.
CP9.
And then
P99.
99 P99, kindly see.
1078 again showed that some action was to be, they proposed that some action is required to be taken.
That's all. That's
After
all.
that, any
Nothing
final
more.
decision.
After that, nothing. While enclosing a copy of representation, all the deputy commissioners of labor in this zone are requested to take at least, Willards,
Right now. The instant writ petition under Article 32 of the Constitution has been filed by 10 writ petitioners, from most of whom are the purported trade union stroke workers union stroke association of domestic workers in different domestic workers of different states. They seek the following directions to the Union of India and various states stroke union territories who have been included as party respondents. All the states are there, or
Yes, it's all other.
don't see various, seek the following directions to all the states and union territories, to Union of India, all the states and union territories. These prayers are page 71 and 72. Have you placed on report that judgment also?
Yes, Milord, that's on record. Annexure P56
Yeah,
is your
this is
Lordship's
page
judgment.
811.
P56, Milord. It's there in the office report also, Milord. It refers to the.
Page 811.
Yes. And would your Lordship like to see the expert committee which gave the report after your Lordship's judgment? We only have a newspaper report of that. That is there, Milord. At P57, page 848, there is only a newspaper report about what the expert committee says after your Lordship's judgment.
The above strict directions have been sought in the backdrop of the detailed observations and certain directions issued by this court in exercise of its powers under Article 142 of the Constitution through a judgment dated 29th January 2025, rendered in so and so, reported so and so. So that was the case where the plight of domestic workers as a result of the lack of legal protection in India was highlighted after giving a detailed reference to the international norms and standards. This court also took notice of the repeated legislative attempts made in the past to enact a comprehensive law for the protection of domestic workers, but unfortunately, none of those bills materialized into formal enactment of a statute. The details of all such bills which were allowed to lapse were given in para 49 of the judgment. Thereafter, this court took cognizance. Thereafter, this court noticed that there was no effective legislative or executive action which could prove to be a boon to millions of vulnerable domestic workers across the country. This was also observed that as a result of the absence of any legislative protection, the domestic workers were excluded from taking benefit of various labor laws like Payment of Wages Act, Equal Remuneration Act, etc.
Paragraph 53 and 54.
This court was conscious of the fact that it would be beyond the scope of the constitutional powers to issue a positive mandamus for enactment of any law. It was thus observed, page 45, on the top sheet, you put page 45, last line of paragraph 53. Thereafter, this court held thus paragraph 54.
Section 846, reduction below.
Direction number 4. Consequently, the following direction was issued through para 55 in bracket Roman 4 and 5 of the cited decision, as I will explain. Para 4 and 5. Next paragraph. It seems that mustering support from the observations made by this court, highlighting the plight of domestic workers, the petitioners' associations took up the cause with their respective state governments as also with the Union of India. It further seems that the Union of India advised was of the opinion that the petitioners ought to approach their respective states for enactment of suitable law for the protection and the benefit of the domestic workers. As none of the state has come forward with any formidable legislative scheme, that the petitioners union have again approached this court. Next paragraph. Notwithstanding the fact that the prayer clause has been drafted in such a manner that it may not look to be seeking a direction from this court for legislative intervention, it may not look as if this court has been paid to issue a mandamus for enactment of a suitable law. We find that on a combined reading of the prayers, especially prayer A and B, no enforceable decree or order can be passed by this court unless a direction to, unless the legislature is commanded, unless the legislature is asked to enact a suitable law. Such a direction, we are afraid, ought not to be issued by this court for the same reasons which we have assigned in para 53 and 54 of our decision in HONBLE's case Supra, which is heavily relied upon by the petitioner. Next paragraph. All that we wish to observe is that the petitioners should continue to highlight, the petitioners may continue to highlight the plight of the domestic helps and impress upon the stakeholders to take a final decision, to take a final call in relation thereto, more so when the correspondence between the petitioners associations, petitioners unions and the state governments suggest that the issue is under active consideration before various state governments. So we hope and trust that a suitable mechanism will be evolved by the competent authority in each state to assist for the betterment of the domestic helps and to prevent their alleged exploitation. The petition is accordingly disposed of. Impressing upon all the state governments to look into the grievance of the petitioner association as highlighted by them in their respective representations. So the petitioners, if so advise, may also forward copies of this petition as a comprehensive representation on their behalf for consideration of the state government. Let's see, we can.
Grateful. I bow to your lordship's order. I have only one small suggested correction where your lordships have indicated that our prayer is for passing a law. The prayer is really for including the schedule because the law is already there.
Passing of like
Including in the schedule to the
for inclusion in the existing law.
in the
For
existing.
inclusion in the
Lordship,
existing.
lordship, please. Grateful, sir.
That can help.
Deeply grateful.
With regard to the maintainability of the reference, your lordships have already entertained my earlier petition, which at page 115, your lordships will find the notice was issued. The office report also shows that. Now, the High Court goes on the basis that I participated in the reference and therefore I can't question maintainability. At page 12 to 16, now I had.
They have already perished.
No, these are contract workers where the Provident Fund, ESI, the appointment letters, the supervision and control, the retirement, the overtime, everything is admittedly given by the contractor. The contractor is a large entity. The contractor is not some fly-by-night person. It's
These facts with regard to the appointment letter, PA, the wage bills, two courts, the tribunal and then the High Court, comes to findings against you. Particularly the appointment letter.
Yes.
On one day, 131 employees are given letter in May 2009. Then the contract between you and the Mangal is in November, in October.
No, that is why we filed a review, because we had only given sample contracts for 2 periods. We filed a review in which we had annexed all the contract notes for the entire period.
Exactly.
But let me just explain.
Do not dislodge these.
Let me straight away answer your lordship's question. Was why 131 letters were given by Mangal on Monday was that we had shifted the unit.
They are
Atit.
unsigned letters produced after the reference.
No, Manoj, I'm sorry, Manoj, during the prior 2009, just come to page 340.
VRS is being given by you to people who retire or.
No, we
Contract
reimburse.
employee retires, you give VRS.
We reimburse the VRS amount. Now, when a contractor makes payments, it's not that the principal employer doesn't reimburse that amount. So just come to page 342 for a moment. Look, there can't be a more clear case. Just come to page 342 for a moment in my review. I should have annexed these documents, but please first of all, let me explain why 131 letters. We had shifted the unit from Karad to Atit, about 40 kilometers away. When it was shifted, Mangal had to give appointment letters at Atit because that was
Place of business.
yes, because there was a cut-off date. So all appointment letters were one date. Now the High Court comes up with this.
Yes, it's a re-arguing the case. These
No, I'm
facts
not-
were before the tribunal.
Just please come.
In fact, in cross-examination, your employer officer says that these were all issued prior to Bengal coming into the picture.
No, there were three contractors. There were three contractors. And all three. Now they don't make the contractors a party. There is a very serious issue here. What they do, they just see the terms of reference for a moment. If your lordship sees
The word is principal employer.
no, but see page 12 for a moment.
Word is principal
How is
employer.
such a
That is why Tata Steel will not, is been correctly distinguished by the judge. He says that if the word was employer, then your argument is correct. He could not have gone into this question
Of sham
as to
contract.
whether a sham employment was being created.
But-
when the question was framed like this, whether the employees could be put into the employment of the principal employer and absorbed in the principal employer's establishment, the reference itself will be subdivided into the issues of whether there was a wheeled employment through a sham employer.
Had it been in the terms, my lord may just consider, had it been in the terms, let me just answer this, Lords, for a moment. What your lordship said is that if it is put me in the employment of the principal employer, that's not the reference. The reference is because I've completed 240 days, I should be made permanent. Just see page 12.
Yes.
See page 12 for a moment. How is this?
In the employee, it is
Just-
whether they should not be
May-
absorbed by the.
No, may I just read that, Lords? Page 12, the reference, schedule. The applicant workers be absorbed in permanent service with respective effect by principal employer Emerson Climate on account of rendering of continuous service of more than 240 days, and they shall be paid all wages payable to permanent workers. They have gone on the basis as though they're temporary employees of the principal employer.
If these workers have been granted all statutory benefits
My
by
lord.
the contractor.
They are.
By the contractor.
Yes.
In any case, you should not be worried because contractor is not going to pay from his pocket. He will charge from you. And whether you pay them directly all these benefits or you pay through contractor.
No, but they are putting them on our rolls. The tribunal now, the High Court says you absorb them on your direct rolls.
Right.
So
therefore, you will not pay to the.
but it amounts to an abolition of a contract labor system. In a case where
That's why in the earlier matter, unfortunately, we know, we know that self-constraint principle. Otherwise, this is what happens. The moment you, these all service providers, a new phase of these contractors, which is coming forward, they are now exploiting everyone.
no,
Otherwise,
here the Contract Labor Regulation and Abolition Act expressly recognizes this. Now we are registered employers. The contractor is a licensed contractor. They don't go for abolition.
No.
And
1970 Act, abolition of contract, the exemptions under that act is understandable. That this service provider or a company or this contractor.
this Mangal is a large organization based in Pune. They are supplying.
But for all intents and purposes, they are your employees. That is the finding of
But
fact.
then the contract labor system gets abolished by the back door. And how is it held to be a sham contract?
We will examine the legal issue. There we are finding it slightly difficult to say that if you are a party to reference, then you can't question the maintainability.
Let's keep aside maintainability. On merits, your lordships have said, just see, my lords, page 16 for a moment. Your lordships have laid down the test, at page, that is the issues. Just come to, my lords, the tests in Balwant Rai Saluja, the 3-judge bench, which your lordship will find, my lords, at page 19. Page 19, these are the tests which have to be met to declare that a contract is sham. Page 19, para 30, your lordships have that, Lord?
Yes.
Yeah. Para 65 of Balwant Rai Saluja, that's the 3-judge bench. Thus, it can be concluded that the relevant factors to be taken into consideration to establish an employer-employee relationship would include, inter alia, one who appoints the workers. In this case,
High Court has applied those very tests of Balwant Rai Saluja, para 32 onwards.
Yes.
High Court has in detail discussed with
that is perverse, my lord, because who appoints the workers? Mangal has appointed the workers. My Lord Honorable Justice Bakshi asked that how did 131 get appointed on one day? It was explained that because the unit was shifted from Karat to Atit, the 131 appointment letters were issued. Now,
It's an explanation you are giving
but they don't,
for us.
they don't deny that they are appointed by
Page 21, this paragraph 32 of the judgment, judges quoted your witness, Shashikant Shirke, who says that Mangal had not entered into legal agreement with us in respect of the concerned workers. Then
we have not entered into legal agreement.
yes, it is true to say first party has not entered into legal agreement with Mangal.
I'm sorry, my lord, the reading at page
21.
Yes, it is to say that first party has not entered into legal agreement with Mangal Enterprises in respect of the concerned worker. This is with regard to a VRS of a worker. We have not entered into the legal agreement. We have entered into an agreement with Mangal for supply of the contract labor for carrying out work.
It is not with VRS, it is with regard to the 5th May letter.
The
5th May 2009 letter.
I'm sorry, it says the industrial tribunal has also questioned as to how 131 workers could be appointed on a single day.
Yes, and
to make the case
we
of
have not entered into agreement at that time.
we had, we produced, if your lordship sees from page 342, in my review, we produced all of them.
So
There was only samples produced at that time. No, this matter requires consideration. This is a case, in my humble submission.
Mr. Singh, the best that you can say that these factual findings are perverse.
That is okay.
From that the law applied by the judges, Balwant.
I'm saying they're perverse and
which have been concurrent.
We filed the review.
By the tribunal and the High Court.
Now, we filed the review because certain, we have given certain sample letters. Then we filed the review, we annexed all the letters.
Big employer, you have the luxury of litigation, filing review, going to Supreme Court.
Look,
by that time, 131, 170 employees are either dead or
not an unrecognized union.
By the time
we have a recognized union under that.
30 employees will be dead and gone.
If your lordship just sees page 341 for a moment. The review is brushed aside, even though my lord may just see page 341 for a moment. The documents we produced in the review, we produced because they said that you have only produced certain agreements.
Mr. Singh, the 131 employees, they have been fighting since when?
They were in since 2013.
So
Settle something.
many of them have died. Many of them have already attained the age of superannuation. Some of them are surviving. You should be magnanimous, you are welfare state and you are such a big, large entity.
But
You should keep the question of law open.
My lord.
We will keep the question of law open.
Please, Lord.
As a humanitarian ground you can implement. We will say it will not be a precedent.
Please, Lord.
We have heard Shri Singh and Senior Counsel for the petitioner. Though there are arguable legal issues raised on behalf of the petitioner, however, keeping in view the particular facts and circumstances of this case, where many workers have already passed away or are senior citizens, and the actual benefit has now been given only to 64 employees, we are not inclined to interfere with the impugned judgment of the High Court. The special petition is accordingly declined. However, the impugned judgment will not be a precedent to be cited, to be relied upon for the grant of benefit to the other employees. The question of law in this regard is kept off.
Deeply
I think that will take care.
Deeply. No, there's some delay because of the review.
That delay is called.
This issue of delayed adjudication, my lords, is being considered by your lordships, my lords, in a batch of matters, my lords, which is now, my lords, listed on the 9th of February, my lords. In fact, my lords, in that, my lords, an order has been passed, my lords, that if this issue comes before any tribunal or the High Court, my lords, they ought to keep the matter in abeyance, my lords.
That is what the High Court has taken.
We should. Lordship, this issue, my lords, of delayed adjudication, my lords, is being considered by your lordships, my lords, in a batch of
What is
matters.
to be considered in this?
My lords, what has happened, my lords, kindly have this order, my lords, and see para 9, my lords. What has happened is, my lords, all over the country, some, my lords, 250 odd matters, my lords, have now been dismissed on this issue, my lords, pursuant to a judgment of the Delhi High Court. My lords, para 9, my lords, your lordships note, my lords, if I may read, my lords, that if this issue comes before any tribunal.
No. What is this, what are those larger issues?
My lords, the larger issue is this, my lords, that all these three acts, my lords, specifically provide that if a show cause notice is issued, then it has to be adjudicated within a timeline, my lords.
What do you mean by within timeline? What is the prejudice caused? Please tell us. Except that one can say that for the delayed period, you will not be saddled with any punitive interest. What is the other prejudice? Original assessment will remain correct.
No, in this case, what happens is, because these are indirect tax matters, once, the show cause is issued, then the act provides that you have to adjudicate this either within a year or if there is some extension. Otherwise, everything terminates.
There is no consequence of otherwise, sir. Don't put in words in the statute. The statute gives a time frame, also gives some elbow space, saying that there may
Where
be
it is possible to do so, that's
whether it
one
is
of the
possible to do so.
I bow down.
So that makes the word shall as may.
That's in
And
one statute.
in 1 year, if it is possible to do so, read with a clause makes the shall may. Then the next reason why the shall ought to be read as may is the consequences of failure are not spelled out in the.
That's correct. That's only in this statute, which is the Finance Act. What happens is, this was amended, by the Customs Act. The legislature intervened and they say.
The Chief Justice indicates to you, it is a question of your being saddled with additional interest because your incidence of taxation or liability is already accrued. Correct? Because of some indolence of an authority in not recording or finding whether the assessment is correct or not, you couldn't be saddled with additional interest. That can be the only consequence of this.
I agree,
But suppose after 5 years, 10 years, the order is passed and you are imposed with a punitive interest because under the Act there are provisions regarding penalty or punitive interest. You are justified to say that it is not your fault. You had submitted all documents, you have filed the whatever the information was required, and if the assessing officer has delayed it, then you are not at fault. But that is not the case here.
No, Manoj, in fact, Manoj, what has happened is, Manoj, that the legislature has intervened and Manoj, there are amendments made in these acts which says, Manoj, if the adjudication is not done in time-bound manner, then Manoj, all proceedings will abate. And Manoj, there's a detailed judgment, Manoj,
So
that
you collude with the employee, this kind of interpretation will breed corruption in the system.
Manoj, all I'm
What are those questions of law we can't understand?
Manoj, but Manoj, this is Manoj, what the order that has been passed. Kindly have para 9, Manoj, for a moment. All I'm stating is, Manoj, this is what the High Court was doing in other matters also. Kindly have para 9 for a moment, Manoj. Manoj, para 9 is, Manoj, the difficulty, Manoj, and this is what we pointed out, Manoj, and this is what is.
We will clarify.
Manoj, then Manoj, may I just show that judgment? Because Manoj, it's not that, Manoj, the only provision was the provision of the service.
These arguments you raised before the appellate tribunal.
Manoj, then,
You have only been relegated to the appellate authority.
Manoj, the appellate authority also will be bound down, Manoj, by this para 9 then, Manoj.
So we do not find any valid ground to interfere with the view taken by the High Court. In fact, the division bench of the High Court has correctly interpreted the expression inverted commas where it is possible to do so, inverted commas closed, in para 4 and 5 of the impugned judgment. The High Court has thus correctly relegated the petitioner to avail the appellate remedy before the appellate authority in terms of the provision referred to in para 6 of the impugned judgment. So consequently, we dismiss the special petition, leaving it open for the petitioner to avail the alternative remedy as permitted by the High Court. Next paragraph.
Manoj, just one indulgence, Manoj.
We have clarified para 9 of the order dated 2nd May 2025, passed by a coordinate bench in SLP civil number 5392/2025, in bracket Union of India versus GMR Airport so and so, to the fact that there shall be no impediment on the appellate authority to decide the petitioner's appeal on merits and in accordance with law.
Manoj, let Manoj, all issues be open and Manoj may give me 3 months time, Manoj, because Manoj, otherwise limitation should not come in play. For Manoj, me to approach the tribunal, Lordships may direct Manoj, give me Manoj.
Limitation, he may be given some time.
Manoj, to approach the tribunal, Manoj may give me 3 months time, Manoj.
In such a discourse, the petitioner is permitted to file the statutory appeal within a period of 4 weeks. 4 weeks.
Very well, Manoj. And Manoj, all issues be
When
open.
such appeal is filed, the appellate authority shall entertain the appeal on merits. Shall entertain the appeal on merits.
And Lordships have not observed anything on merits because Manoj, I'll argue in this case, Manoj, they sat for 2 years, Manoj, I'll argue all of those points before the tribunal. Manoj, nothing on merits, Manoj, if the Lordships can add. Manoj, no observations on merits, Manoj. I will argue everything, Manoj, before the tribunal. Obliged, Manoj.
You have said so, I think. Not decided anything on merits.
Absolutely right, the VCS interpreted.
Mullad's the learned division bench has reversed the learned single judge and thereby Mullad's rejected the request by the Mullad's District Court of Delaware in the US under the Hague Convention. Mullad's in terms that Mullad's in my respectful submission are contrary to the very terms of the convention and also its object. If my lords just have page 32 with me, Mullad's, of the paper book. At paragraph 32 and 33, Mullad's.
Well, let us see the reasoning of the High Court. What is?
Yes, Mullad's, I am showing you just that, Mullad's.
India card easy. registration of patent because of the patent registered by the defendant.
No, that's the
India.
error, Mullah, on fact. The defendant is a manufacturer. He has no patent.
No patent.
There's a misunderstanding, Mullah.
Your patent was refused by the
Yeah, but
patent
nothing to
office
do
in
with the
India.
manufacturer. Mullah, I have a US patent and I
You
sued
have a
in the
US
US.
patent, you
Right.
wanted to register it in India.
No, no, well, that is not relevant here. Because I have a US patent where I sued Mullah
We understand
in
it's
court
not
of Delaware.
relevant. The High Court,
Yes.
division bench, feels that is a question of national interest on which Article 12 may be invoked of the Hague Conference.
That's what I wanted to tell you, Mullah. This has nothing to do with the rejection of my patent in
That's
India
your argument.
at all.
That's your.
And that's the error, Mullah. Because on a
Two
misimpression.
articles you have to explain, Article 23 and Article 2.
Yes.
Article 23 also puts an embargo on non-specificity.
I'm grateful.
Statement.
Can I just tell my lords why sovereignty doesn't come into it?
Don't worry, you should not.
Well, there's some urgency, my lords, which is that the trial in the District Court of Delaware is to commence on April 27th. They made the request in 24.
Judges already are there, madam?
Yes, I'm for the caveator clause.
You have to-
My lord,
you are for the.
for the caveat, sole respondent, the caveator clause. Yes.
You can accept notice.
My lords, there's only a submission that I would want to make. My lords, the exception by the Delaware court has already expired. My lords, I am being lead by senior counsel.
With your lordship's leave.
Yes.
No, you should file your counter.
I'll do that, madam. Well, I'll come.
At least we will.
Well, in light of the no,
Pre-trial proceedings- I have proceedings already in Delaware. Sorry.
well, April 27 is the trial.
These facts only. It's a trial, but
Yes.
this is an interrogatory, sir.
Yes.
For pre-trial discovery.
That's right.
So you get a new interrogatory during trial, Article 23 will not apply.
That's
If
it.
you consider this, Mr. Sipal.
Yes.
You have always a right, irrespective of this finding, we can say that the findings will not be binding into parties. You can make an interrogatory in the courts of.
No, my lords are issuing notice for us in my petition.
Will it be of any purpose now when the trial proceedings are already commencing?
Not commenced, my lords. It will commence April 27, my lords. It's not commenced. The request was made in 24. Can I just tell my lords? The request was,
In your synopsis, page Z, last page.
yes, my lords. I'm on page Z, my lords.
Stop. J. 825.
Right. Well, can I just say, the request was made in 24 to gather evidence from two parties. One is the respondent, the other is one Tina Labs Limited. Tina Labs Limited being in Telangana, we approached the Telangana High Court, which accepted the request and executed the request, and the evidence has been collected and sent to the District Court of Delaware. We approached the Madras High Court, which also accepted in the first instance,
And then.
but is reversed here. All we need, Mullahs, is that there is sufficient time between January and April for us to gather that evidence if our SLP Mullahs is allowed. And therefore, we are saying that is the request before my lords. It is not infructuous, Mullahs. Because we are seeking a final hearing in this matter so that on principles of committee, these reciprocal obligations, but so we also issue letters rogatory, they also have to comply.
We are, anyway, we are seeking counter, but next time we would like to know that if an Indian company will go
Yes.
and seek this kind of
Yes,
privacy, will they issue?
Yes, my lords, they are obligated to do it.
No.
They do it, my lords. I'll give you instances.
Obligated is something else. We would like to see your decision.
They must do that. My lords are right.
Please, and,
It has to be
We will not
reciprocal.
compromise with the sovereignty of our nation.
My lords are right.
We should be very
I'm
clear.
with my lords, my lords.
That's why we are issuing notice. We want to settle
It has
this
to
law.
be reciprocal, my
But in
lords.
fact, in Coca-Cola, when they
It
asked
is
for
the very
the chemical
foundation of
analysis,
reciprocity. Without
When
reciprocity,
the Indian entity will go there.
My lords
then
are right.
How are they dealt with?
Must be.
We would like to
Must
know
be.
it.
I'm obliged.
obliged.
Because can I have a date for final hearing, my lords? Otherwise,
Final hearing, not, let them file the counter 4 weeks.
was the date returnable in that case, my
You
lords?
can file 2 weeks in counter.
Yes.
Can it be 3 weeks because?
Because we only need a week, my lords, after that.
And if you so advise, you can, to my mind, the Union of India should be a party here. We would like to have the union's opinion also.
And was they are not prejudiced because, my lords, this is
So it's not a question of
confidentiality.
prejudice.
Club has
It's a
been set
question
up.
of, it's a question of the sanctity of the sovereignty.
Because I just want to point, sovereignty doesn't come into it, they are a private
It
party.
does come, it does come.
Was not-
When you want to have an information, you want to hijack information from any part of the globe. When question of getting information from you come, then you pose your superiority. That is the issue that requires the determination. And we will determine it.
my lords.
It's not that we are issuing notice that we are convinced with your contention. We are issuing for a different purpose.
No, I like my lords, my lords, it has to be reciprocal, but my lords, sovereignty will.
Reciprocal, how it is
Private
being
party.
effected? Reciprocal is only because of the Hague Convention you are talking. Question is that how are they honoring it?
So it must be honored on both sides, my lords, no doubt
It
about it.
must be, therefore, onus will be on you to
We'll
show
come
that
with
it is
examples.
being honored in the past.
We'll come with examples, my lords. We'll come with examples. I'm obliged. And also, my lords, in India also, we have followed this in light of that
In
reciprocity.
India, we
our court
follow.
Followed it.
In India, we follow because we believe in committee of courts. We believe in mutual
It
respect.
must be on both sides.
And we believe in respecting the other sovereignty also.
It must be on both sides.
We are,
sir.
that is the issue.
Because we are with my lords. So obliged. Great.
Obliged,
Could
obliged.
could there be a date returnable, my lords?
Yes, of course. We file it within 2 weeks or so. Fix a date after 3 weeks. On a non-miscellaneous date.
Great. Obliged. Grateful.
Please, my lord. My lord, may I? My lord, may I? My lord, my lord, appear for the petitioner in this matter, my lord. My lord, with utmost respect, like to submit, my lords, I am not seeking adjudication on the merits of the case pending before the Honorable High Court of Allahabad. Rather, I am seeking expeditious pendency of the Allahabad.
Every day these kind of petitions are coming. You are not asking, you are raising something new.
My lord, the issue of my only grievance,
Allahabad High Court's day-to-day functioning, now we are being prompted that court number 1 here in Supreme Court should run that affair.
my lord, if I may submit, my lord. My lord, the time is the essence in this matter, my lord. My lord, the sequence, if I come from a scheduled caste category, my lord, both of my parents have already been expired in the last 2-3 years. A person when applies for a government job, my lord,
Right down.
he has certain expectation.
Petition under Article 32 has been filed, seeking expeditious disposal of CMWP Group A, number 10326/2023, pending before the Allahabad High Court. In our considered opinion, no such mandamus can be issued by this court, which would amount to interfering into the prerogative of Honorable Chief Justice of this side Allahabad, of this side High Court. If there is any urgency in the matter on the basis of which the petition requires out of turn hearing, the petitioner may approach the High Court with an appropriate application. With the liberty of government, they will put it in business.
Obvious, my lord, grateful.
Item 13,
Just to be listed on Tuesday, my lords had suggested on, Lordship, my lords had said Tuesday.
Item 13.
Yes, my lord.
Yes, Lordship, yes,
13 yesterday there was mentioned by
Yes.
both sides.
yes, Lordship, that's correct.
Whatever date we had probably.
Requesting if Monday is possible. If Monday is possible.
No question on Monday.
Tuesday, Lordship, at
No. We said this will go to next week.
Lordship, if,
It will be on 11th February.
Lordship, there is a little issue. We are,
11th February.
Lordship, they are going to launch the product. I had with great difficulty could manage an urgent filing. I'm just, it was on my learned friend's counsel was not.
Don't worry, we will.
Lordship, I was just indulgent to my learned friend and I will be in difficulty. Now, I'm just requesting, Lordship, at yesterday's suggested Tuesday, Lordship may have it on Tuesday. I'm just requesting that. It's a humble request, my lords. It's going to come for the first time. It's a patent matter.
All right, on 4th February.
Much obliged, Lordship. Much.
Please, my lord. Because this is a matter where I had no other option. With respect, we have nothing against the Honorable Judge, but he has already given his mind and the Milords and the Honorable High Court notes that fact. In fact, what is the point in sending it back, Milords? If my lord, I have Milords, if my lord will see para 7, it has been pointed out to the Honorable Court that this learned arbitrator in a different arbitration proceeding is all. So where is the, in fact, and in fact the High Court says I am not getting into it.
You see, will it be?
Because I understand, I also found it.
That's our predicament. How is
My predicament also, I
not point out to the learned arbitrator that.
No, because he has already ruled on this very aspect. That's my point. I can't go to that because it will be hit by Schedule 5 also. It will be not a personal bias, but what do I do? In fact, interestingly, the Honorable High Court notes that fact. If my lord will have the order passed by the learned. Now today otherwise this is remediless. Even if I go there, they'll move a section 16, he will be bound. Any order, I would not, because I found it very difficult when I had to, but this is something apparent on the face of it. What do we do? Because we have with due respect, Milord, we have nothing against the Honorable
Serve them for next week or so. We are issuing notice, you serve them for next week or so.
Can I pray for stay? Otherwise,
No, it doesn't look nice. It doesn't look nice.
for me also it was very difficult to, please, Manoj, I am obliged.
Please, Your Lordships. This is a matter where the members of the COC are the asset reconstruction companies, and the resolution applicant are the entities of which promoters are the promoters of the members of the COC. So asset reconstruction companies, they control the COC, and the resolution applicant is also a member connected to the members of the COC. My lords, we are the promoters of the company. We pointed out before the NCLT that, sir, in the information memorandum, a basic document basis which plans are received discloses only one property out of 4 properties. Juhu is the place where there are 2 properties situated, Project 1 and Project 2. Project 1 has 50 flats constructed, value of which, least market value of which is 1,500 crores. Other property is built up at a plinth level, same at Juhu Beach, 2 towers. Approvals are obtained in respect to all the 3 towers from the competent authorities, including FSI. I point out that, sir, the IM issued by the RP is defective for 2 reasons. One, it doesn't disclose additional land at the Juhu between these properties and the beach, admitting 26,000 square meter. 1. 8 acres of land in Elephanta Island, worth about crores and crores of rupees. No disclosure. I move a request to the RP. Please place this matter before the COC for their consideration. Not placed. I move an application to the NCLT, rejected. I come to the NCLAT. NCLAT says, list with other pending batch of matters. Meanwhile, NCLT can proceed further to decide the pending applications. Number one, the pending application is an application filed for approval by the RP. The difficulty is, difficulty it is facing for the right concession. Difficulty is this, that the NCLAT says appeal list with other matters coming up on 4-2.
No, you can request NCLAT, that's what to,
They may consider my stay application because otherwise today plan is for approval before the NCLT. Once the plan gets approved, there will be equities created in favor of third parties.
If person was himself slept over these facts.
Day 1. The IM was published on 3rd June.
When IM was published, before that you were approached. You did not give these particulars to the resolution.
Sorry. Can I place it for my lord's final approval?
25/5/25 is the date of uploading the IM for the first time. 25/5/25. 3rd June is first revision. I wrote to them on 6th of June. 6th of June, I wrote to them pointing out that, sir, IM does not disclose A, B, C, D properties, A, B, C, D approvals.
Before May 25.
Yes, ma'am.
We were approached by the resolution professional to disclose all your assets and all the assets of the corporate data. You chose to remain silent.
I have
And this is what NCLT comments, that this is a structured, programmed exercise to delay the process, delay the process. And in any case, we are not going to entertain appeal against this kind of order. Simply, incorrect or simply said, pendency of appeal is not.
This IBC, as my lords are aware, had or time bound program.
This is exactly.
The entire appeal, there are 9 appeals before the entire today. In none of the appeals, there is the order.
Passed by the NCLT. With the further observation that pendency of the appeal cannot affect the pending proceeding before the adjudicatory authority. So we are not inclined to entertain this appeal. Also, when the appellants are at liberty to raise all their contentions before the appellate tribunal. As regard to the plea of urgency, we grant liberty to the appellants to move an appropriate application before the appellate tribunal, which may be considered sympathetic. With this liberty and observation, the appeal is discussed.
Or she must have taken up expeditiously by the application which I moved.
There is nothing more we can add now.
Very well, sir. Much obliged. Grateful to your lordship.
This is a matter which.
That's the problem now. How many matters we direct the Allahabad High Court? Every day now 2, 3, 4 petitions are coming. Now they have become a trend in the Supreme Court.
94, Your Honor, the affair of law in 94, Your Honor. 3 decades we have.
I understand you are an 84-year-old. Ismail is the instant petition under Article 32 of the Constitution has been filed seeking a direction for expeditious disposal of application section 482, number 46070/2023, pending before the Allahabad High Court. So the aforesaid petition is stated to have been filed seeking quashing of the FIR in a matrimonial dispute. The petitioner happens to be an 84-year-old widow who is mother-in-law of the complainant. Next problem. As the prayer made this reputation would amount to interfering in the prerogative and powers of Honorable Chief Justice of the Allahabad High Court. We are not inclined to entertain this petition. The petitioner shall be at liberty to move an application before the High Court seeking out-of-turn hearing of her petition, keeping in view the age and other hardships being faced by her. We have no reason the High Court the High Court is requested to consider such application sympathy.
Right. Lordship, please.
ये 18 की बस 17 कहाँ से आ जाता है?
Lordship,
Yes, item 17.
Lordship,
Already
Lordship, here is the item 17. I was not a party to the proceeding, Lordship. And the Honorable High Court, by this
service is complete. The service complete. What kind of drafting it is there? Very poorly drafted SLP. No head, no tail.
Lordship,
अरे वो तो थोड़ा
synopsis is there. Synopsis is there. Synopsis is there.
Yes.
Yes.
There is no necessity for.
Thereafter, on 7th, this order was passed, and from 10th, this was winter vacation. for 30 days. Now court will open on 10th of February. Now the High Court directed to produce the report in 30 days.
So therefore, what prevents you to approaching the High Court telling that you can't pass this order without hearing me?
Lordship, that because I came to know about this order on 10th.
So therefore, if the time you have taken in filing this SLP with such a vague prayer and without disclosing the proper facts even, go and approach the High Court. The petitioner the petitioner through the instant special petition challenges an interlocutory order dated 7th January 2026 passed by a division bench of the High Court of Uttarakhand, wherein certain adverse observations have been made against the petitioner, and a report from the vigilance wing has also been sought. The primary ground taken by the petitioner is that he was not heard before making adverse comments or issuing the above stated direction. So, in our considered opinion, the appropriate recourse for the petitioner would be to move an application before the High Court for recalling of the adverse comments or the directions issued against him. So, the petitioner, if so advised, may move such an application before the High Court, which may be considered in accordance with law.
Till the opening of the, because court is going to open on 10th of February.
10th February, not 10th February is only 1 week left.
Till then, this order implementation of this order may be stayed. Till then, the reason being because they will approach us because vigilance department direction is to the superintendent.
No, we will not pass any interim direction.
Till then,
please go and approach the High Court. Yes, item 18.
I'm praying for the same order as is given in Annexure P2, my lord.
We have granted relief to you also.
Yes, my lords. My lords have given me interim.
Issue notice returnable 23rd February 26, tag with SLP. Diary number 616/2026.
R2 may be deleted from the area.
Meanwhile, no sections have been taken against the petitioner pursuant to the implementation date 17 December 25.
Grateful, my
Number 2.
R2 is the accused in the trial, my lord. I have sought his deletion because he would not be required for these proceedings.
All right, that may be deleted.
It will be except for state.
Judgment dated 17 December 25. Are you appealing paper?
For state, my lords, we are accepting
Then
notice.
say accept notice on behalf of the state.
State, my lord.
Number 2 को delete कर दीजिए. The application includes judgment dated 17 December of the High Court.
Grateful, madam.
Lordship, we are seeking anticipatory bail on the ground that investigation has been completed and charge sheet has been filed. And on last date, on the 15th of January, we have been directed to comply certain order, my lord. We have already complied, my lords.
Milords appearing for the state, Milords. Milords.
Are you appealing?
Milords appearing for the state, Milords. Kindly seeking time to file the reply, Milords.
What reply will do it will matter. Matrimonial dispute, he has deposited 1 lakh, will allow the wife to.
Kindly, Milords, allowed to file a reply, Milords.
And what about the service of responder 2? Okay. The council speaks and granted 2 weeks time to file the counter affidavit. As per the office report, service on responder 2, when the wife is still awaited. Let the petitioner serve responder through gusty notice, which may be served through the local council, who is representing her before the trial court.
Meanwhile, ST maybe the rest of ST might be the more continue, my lord.
Order dated 15th January 26 to continue.
Oblige, my lords.
short-term FDR, achieve the maximum rate of interest.
Yes, my lords, I am appealing for the petition, my lords. This is after notice matter, my lords.
My lords, we have filed the counter, that is yet not on the record, my. We have filed the counter, but that is not yet on the record, my lord.
My lords, the copy may be supplied to us.
What is there now? Why to cancel the bail?
He has suppressed the fact, my lords, that he has utilized, he has received.
Your state lawyer was there. He also suppressed the fact.
The state's counsel was there, my lords.
Nothing.
And my lords, the charges have already been framed, my lords, under section 406 and 109 IP.
काउंटर एफिडेविट मंगा करके रिपोर्ट पे लगा दो काउंटर एफिडेविट को रिपोर्ट पे लगा दो लीव ग्रांटेड the instant appeal is directed against POV dated 6 January 2026 past 12 the Gwalior bench of the High Court of Madhya Pradesh whereby the regular bail granted to the petitioner has been cancelled. It may be noticed that the petitioner is one of the accused in FIR number 386/2021 registered at police station Polaras, District Supri under section 409 IPC. The allegations pertain to embezzlement of funds from the District Cooperative Central Bank where the petitioner was working. यहाँ पे लिखा है 409, 409, 420, 467, 468, 471, 120B and 201 IPC. Read the section. This was the charge sheet. So the petitioner was arrested. The appellant was arrested on 6/1/2024. Thereafter, charge sheet under section so and so will be read with section 13(1)A, 13(1)B and 13 in chapter 2 of the Prevention of Corruption Act was filed against him for cycling of 5.21 crores. Him and other accused. He is not the so it was 5.21 crores by the appellant and its co-accused. The appellant was eventually granted regular bail by the High Court on 18th March 2025. That order has been cancelled and the bail, that order granting bail to the appellant has been cancelled. Interviewed on the ground that the appellant suppressed the material facts regarding the deposit of 47 lakhs in his account, etc. That's why we mentioned that the regular bail was granted to the appellant after hearing the state counsel. The alleged suppressed facts were not brought to the notice of the High Court by the state counsel also, by the prosecution also, In any case, the trial has commenced. No useful purpose will be served by questions that are on board. Other questions that are has commenced. The appellant's co-accused are already on bail. No useful purpose will be served by keeping the appellant in judicial custody. So, consequently, the hearing is allowed to be implemented order of the High Court is satisfied. The previous order of the High Court granting bail to the appellant is restored.
Please, my lord. My lord, the petitioner is advocate and my lord citizen of the country. My lord, the guideline issued by UGC, my lord, that it dismantles the procedural safeguard guaranteed by the Constitution of India, my lord, and my lords are supervisors of the Constitution, my lord. So it may be protected, my lord. May be protected. All the citizens may be protected, my lord. Otherwise, it will disturb the very mandate of the Constitution and very mandate of the socio-cultural and geographical. All these things, my lord.
My lords, we are actually challenging section 3C of the definition.
Lordship may kindly have it for a moment.
My lord, I am appearing.
Because section 3C of the definition of the UGC regulations.
Your Lordship, may I begin with? I am appearing in item number 30.
For a moment, Lordship.
Hear all of you. Please wait. Have patience. We'll hear all of you. if need be.
Please, Your Lordship.
May I just read, Lords, if Lordships permit, section 3C. Caste-based discrimination. Caste-based discrimination means discrimination only on the basis of caste or tribe against the members of scheduled caste, scheduled tribes and other backward classes. My lords, my respectful submission is that this is completely exclusive. The members of the general category, Lordship may for a moment have a party. The discrimination, the definition which is of discrimination is all encompassing.
Now read the definition of discrimination.
Yes, my lord. Discrimination means any unfair, differential or biased treatment or any such act against any stakeholder, whether explicit or implicit, on the grounds only of religion, race, caste, gender, place of birth, disability or any of them. It also includes any distinction, exclusion, limitation or preference which has the purpose or effect of nullifying or impairing equality of treatment in education and in particular of imposing conditions on any stakeholder or group of stakeholders which are incompatible with human dignity. Stakeholders is also defined, my lords. Now, my lords, when my respectful submission is when section 3E is already in place, what is the need of section 3C? And section 3C it has no reasonable nexus with the object sought to be achieved. There is no intelligible differentia and it is having a presumption that only a particular section of the society will be having a caste-based discrimination. And let me be very, as an officer of the court, I have, my lords, gone through the entire record of the Abid Salim matter also, my lord. The drift of the orders of this honorable court was not this.
No, never.
It was not this, my lord, which has been ultimately legislated. And this will create, my lords, further divisions in the society. My lords, though, my lords, I do not want to get there, though in the petition which has led to this present regulations, lot of instances have been given. But I have also many instances of,
we don't.
but I am not on instances.
We are simply examining it on the threshold of the
Article 14.
constitutionality
Yes, madam.
and legality.
I am so grateful.
Otherwise, instances.
Can be on both sides. I am so grateful. Yes,
that will be.
Yes, my lord.
My lord,
My lords, this caste-based discrimination, I am seeking a stay on this definition of caste-based discrimination, as well as, lordship may kindly see, my lords, I want to cite one judgment of this honorable court in Paradise Printers versus Union of India. Lordship may for a moment have section, paragraph 14 of that judgment. And if lordship.
You just read.
Yes, my lord. This is, my lords, Paradise Printers versus Union Territory of Chandigarh. This paragraph 14 I am reading. This takes us to the question whether the revised policy adopted by Chandigarh administration to allot smaller sites to these appellates was discriminatory and violative of Article 14 of the Constitution. The true meaning and scope of Article 14 has been stated and restated in strings of decisions of this court. It is now well established that Article 14 forbids class legislation, but does not forbid reasonable classification for the purpose of legislation. In order, however, to pass the test of permissible classification, two conditions must be fulfilled, namely that the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group, and that the differentia must have a rational relation to the object sought to be achieved by the statute in question. The classification may be founded on different bases, namely geographical or according to objects or occupations or like. What is necessary there must be nexus between the basis of classification and the object of the act under the consideration. S.R. Das, Chief Justice speaking for this court in Ramakrishna Dalmia versus Justice S.R. Tendulkar, has formulated various aspects.
Mr. Jan, these principles are very well known. There is no need to even read it.
So, lords, my respectful submission is, that this definition, section 3C, is completely hit by the provisions of Article 14, and when already section 3E is in place, discrimination has been defined. Then, my lords, you cannot assume or presume, a statute cannot presume that a discrimination will be only by a certain section of the society. Lordship will kindly appreciate this submission.
What will the he will answer. Suppose
Yes, ma'am.
there is a student of South India, there is caste factor is not known, but suppose he gets admission in a institute which is in North India,
Yes.
or a student belonging to Northeast get admission say in the northern part of this country, and some kind of sarcastic, insulting or humiliating remarks are made against such student,
Yes.
and even those who are making comments are there, even their caste identity is also not known. Will this provision address that issue?
He will address that issue. My respectful submission is that 3E will address this issue. If Lordships may permit, may I just read discrimination again?
Place of birth.
Discrimination.
From place, your lordship, it covers your lordship. From place, it is says your lordship that if there is discrimination, it basically it covers all types of discrimination. Discrimination on the basis of sex, discrimination on the basis of place, discrimination on the basis of caste, discrimination on the basis of religion, discrimination on the basis of disability, discrimination on the basis of EWS. Your lordship, or grievance is your lordship, but your lordship may see the only known discrimination entire the world in all universities, in all colleges is ragging, which is the real problem in all universities, in all colleges. My lords may kindly see, if I am a general category student, I am a fresher. When I enter in a college or university, by my appearance, see, by my appearance, by my look, a senior will come to know that I am fresher, and I'll face the ragging. If my that senior belong to scheduled caste, and I'll resist, and if I dare to make his complaint, definitely I'll face a cross case where allegation will be the caste-based discrimination. The very regulation which this 2020, which is effective from 15 January 2020, may kindly
just a minute, please. Whether your complaint of ragging will be entertained under this provision?
Your lordship, no, I have no remedy. I am helpless because in this regulation, ragging is not defined, your lordship. They have not even defined ragging.
Used to be there under the old regulations.
But in old, new, they have not covered ragging, your lordship. This is the problem. And your lordship, when there will be caste-based discrimination, the equity squad reported the police, and police will, your lordship, as you know, the anticipatory bail is not in a STC case because our honorable government has already, by making a bill, has amended the STC. Now this fresher boy who is coming to the college will face the bars and will go behind the jails, and his career may come to an end by entering in the college in first day or first month and first year. Because your lordship, the general category student, this recognizes as them criminal. Your lordship, why the definition of ragging was removed from this very regulation? Well, this regulation was supposed to be progressive, but is regressive. What it only tackles the caste-based issues. It does not take in the issues which really exist in universities, in colleges, in campuses. It only thinks that the India is divided only in the caste. It does not support that universities are divided in senior and juniors, where are certain parameters, where are certain cultures. It says that even a fresher who is from general category can assault, can commit, can harass a scheduled caste, a scheduled tribe, as OBC, who may be his senior. Your lordship, in 2012 Act, your lordship, it says if institutions discriminate.
What will happen? What is there any? What is the contemplation? Say in most of the states now.
Yes, your lordship.
Not most, but some of the states.
Yes.
Even the legislature has having realized, or the state has having realized that there is now, even within a reserve community,
yes, your lordship,
there are people who have become virtually haves and the others are have-nots, or a one particular community is caste within that reserve caste. Some communities are enjoying better benefit as compared to others.
Please.
And therefore they have divided them, say, group A and group B.
Please.
Like for example in Punjab, there are some scheduled caste categories who are in group B, the others are in group A.
Please.
There are in Haryana also, there are some scheduled castes in group B, the others are in group A. It is their wisdom, policy makers' wisdom, that they thought that those who are in group A are in a better position among the reserve category, and therefore with a view to promote the other communities within that reserve category. So the B group has been identified. Now suppose a student belonging to A group of scheduled caste, if he commits something uses insulting language or words against the of B group, is there any remedy against it?
No protection in this regulation. My lord, may kindly see. Your lordship, it is not regulation, it is accusation, your lordship. It is accusation, your lordship, it is not regulation.
Has anybody examined this aspect?
See the.
Has anybody examined this aspect?
My lord, I do not know about the matter, my lord, but as per the discussion which is going on.
In a country after 75 years, whatever we have gained in terms of developing a casteless society,
Correct.
are we going in a regressive policy?
And your lordship, it is class, they
What
have
will happen
put the class in the
within
base of
the
caste.
same group? What will happen?
Yes, my lord. Then another example which my lords were pleased to give regarding someone coming from one region of the country to another region,
Unfortunately, ragging, that is the worst things which are happening in case of ragging. The children who are coming, say, from faraway places like Northeast, or those who will be coming from South, and they carry their cultural values with them. There is nothing wrong there, and they should pay, and everybody should feel proud of them when they, in day-to-day life, they follow that very routine. And somebody who is completely alien to this kind of culture, he starts commenting on that in the students.
Yes, sir.
And another provision which I am finding is this. An indication among the measures you are taking, you are talking of separate hostels. For God's sake, please don't do that. We have been in hostels. Every community students have been living together.
Yes,
your lordship.
caste, creed, religion.
Your lordship.
Slowly we have developed the intercaste marriages also. in
Yes,
this
your
society.
lordship.
We should move
But
forward.
UGC must know this,
develop
your
a
lordship.
casteless society.
But UGC must know, they are dividing the university campuses into the caste. Your lordship, if this will be exist, your lordship,
But at the same time, there is some effective mechanism. Those who are subjected to this
we can propose better drafts, your lordship, than this. This is,
Even a lowest.
this entire regulation must be quashed, your lordship.
Yes.
This entire regulation. My lords, stay is.
Now keep in abeyance. This.
My lord, stay is very necessary. Otherwise, it will destroy the. Because colleges are going to, your new admission are going to there.
Yes.
Ragging will happen and cross cases will come, and because of ST.
When the definition of ragging
That is not a very relevant constitutional question.
Constitutional.
If there is,
May I submit constitutional question, your lordship?
please consider.
Please
this.
allow.
One point is Article 15 Clause 4 empowers the state to make special laws for scheduled caste, scheduled tribes.
Please, your lordship.
But your point is well taken. If the 2012 regulations spoke of a more widespread and all-inclusive discrimination, including discrimination in the nature of ragging, why should there be a regression in a protective or ameliorative legislation? Principle of non-regression is evolved essentially in environment law. This also pervades in laws which are protective of social justice and equality.
And my lord, may I submit, my lord?
Here that we should not, we should not go to a stage where we go to segregated schools as in the United States with colored children going.
Yes, sir. But it should not.
One school and other white boys and girls going to another school. We shouldn't have, the unity of India must be reflected in the educational institution.
Yes, ma'am. So great.
It
is a constitutional issue, my lord.
That is the issue, Mr.
Absolutely.
This kind of situation can be exploited by the mischievous elements in society.
Even in this politically charged environment, your lordship, there are frequent comments by the political party spokespersons that the person of general category must be implicated because they have enjoyed the benefits in from 1,000 years. Your lordship, when there is call from political parties, what is the future of general category?
Just a minute, please. We have understood. My brother has pointed out. We understand. You are wrong to some extent, but you are right also. Seems to be right.
Get time.
We want to examine that part. Mr. Solicitor General, we would like to have your response, number one.
We shall file.
Also, please, today we don't want to pass an order of directing you to constitute some committee which should be some eminent jurist. Of course, we like that the court should be taken into consideration, should be taken into confidence, and we should approve the composition of your committee. But some eminent scholar, academician, some eminent jurist, some 2-3%, and those who understand our social ethos, social values, how much we have progressed, what are the ailments the society is still facing. You can't have the universities only in schools, colleges in isolation. They are a component of the society. How the entire society should grow, in which direction we should go, how the people are going to behave outside the campus if we create this kind of environment inside the campus. All these issues, we have also, may not be the fully expert on these things, but those who are the social engineers, those who understand the society's issue, they must apply their mind.
No, certainly. That
Meanwhile, operator may
having fallen from your lordship's order, we
Meanwhile, operation of impugned regulation may be stayed, your lordship.
Kept in abeyance.
But in the meantime, the operation of the regulations.
Kept in abeyance.
Lord, may I be permitted?
Kept in abeyance.
Kindly see
Let him
the.
finish. Let him finish.
Madam Indra, are these the same regulations which NDPI and
Lord,
we are-
he is not a party in this matter. My lord, he is not a party in this matter, my lord.
My lord,
Just a minute. We know that she has been appearing in the matter before us.
my lord, propriety demanded that they should have made a mention of the pending petition in this honorable court, which your lordships have been monitoring, the process via which these regulations have been passed. There is no mention, although orally my learned friend betrayed knowledge of the existence of that petition. Courtesy demanded for a full and free disclosure that such a petition was filed in the year 2019, challenging the 2012 regulations, which the 2026 regulations now replace. That being said, that apart.
Madam Indra, in the,
Yes.
while challenging the 2012 regulations,
Yes.
we can't go further backward. That instead of.
Because, my lord, if your lordship just reads the order dated 15th September 2025, passed by
our
the
order.
Honorable Court, kindly have a look at that order.
That's right.
Yes. My lord, it specifically lays down what are the issues that are required to be considered.
Absolutely.
Why finalizing? Now, my lord, if your lordship looks at them one by one from para 3 onwards, prohibition of discriminatory practices. There must be a clear ban on all known forms of discrimination and enforcing disciplinary consequences for violation. 2, non-segregation. Well, now, this is the issue that's bothering my lords. Do we need
He said
separate
there should be
hostels?
no segregation.
Yes.
Non-segregation, my lord. And therefore, there shall be no segregation.
Unfortunately-
Segregation results in apartheid.
Unfortunately, Madam Indra.
And that was
Going
my
back to-
grievance. It's my grievance when I came to court. I gave you examples where in hostels, SC/ST students are being segregated. At eating places, they are being
Now,
segregated.
some examples I have enabled with my petition, your lordship.
Examples you can also give.
Some examples I have enabled with my petition.
let's
What have they done is-
examples.
Whether you've had your say, allow me to have my say.
What they have done is exactly what you have argued, contrary to that.
Not me, my lord. Your lordship expressed concerns.
My
lord, in order, yes.
We had said that there will be completely no segregation. That principle of philosophy of no segregation will be followed.
This is what this regulation is intended to target.
Can you imagine now with the definition?
She's saying the same thing my lord said more vociferously, that's all.
Mr. Mehta, no personal comments, please. I could say a lot about your voice. If you really want to know, I can tell you what your voice sounds
Please,
like.
please.
Yes. Lord, let's not get into these side issues. This is a very serious matter. And, Lord, first of all, it cannot be dealt with independently of the earlier petition. That's the point I wish to make.
Yes, you are right. There you are right. What is the date in that matter?
It's 19th March. 19th March. This is just an attempt to overreach the orders of the court.
No, we will hear both matters.
That petition.
If need, we will
Propriety demanded that they make a disclosure, which they did not do.
issue notice for 19th March is the date. Issue notice.
19th March. My lord, I also want to point out
Regulation may be.
the concern that my lord had of a all-inclusive society. This is the objective of these regulations.
This is what we have been arguing before us, and this is what we have also followed. But the regulations are very, we are sorry to say, prima facie, the language, there is complete vagueness, the provisions are capable of misuse, and there may be that somebody will, some with experts advise the language need to be certain remodulated or clarified.
My lord, if you give me an opportunity on the merits, once this matter is tagged along with the other matter, I will convince you that it is not so. Give me 1 second, my lord. He read.
We will hear both matters to us.
1 second. He read regulation number 3C. I urge you to read regulation number 3E. Read the definition.
I read E also.
My lord.
I read
We have read it. Already we have read it.
Please, sir.
This is not right, my lord.
Counsel.
Heckling, I
You
was
address the
expecting
judge,
in the courtroom.
not another counsel.
Don't address it like this.
I was expecting this heckling, my lord, and I was half inclined not to come to the courtroom, but it's too serious an issue to bypass.
Madam, please consider our concern.
Yes, my lord.
We are looking into the evolution of the regulation to create a free and a equitable atmosphere in universities.
Inclusive, my lord, inclusive.
Inclusive, as you say. Now, when we see this, we find no reason when 2E is subsisting as it was in the 2012 regulations.
Definition of discrimination.
Ma'am, 2E subsisting, how does 2C become relevant?
So,
is it a redundancy? How do we
I
interpret
understand
it?
the question, my lord. I understand the question put to me.
Therefore,
Question.
we would like your assistance.
Yes, my lord.
Your constitutional principle,
Yes, my lord.
Gradients.
purely on constitutional principle, nothing more.
I understand the question is, can there be discrimination within discrimination? It is a question to be answered. I will definitely answer the question to the best of my ability. But my lord, prima facie, I will also point you to the language of 15(1) for a moment, just one moment. This question has plagued the Supreme Court of India since its inception. Since it goes back to Narsu Appu's case, my lord, decided by the Bombay High Court. This is not a new question. My lord, just read it. Article 15, the state shall not discriminate against any citizen on grounds only of religion.
Absolutely.
So therefore, my lord, the question before this court is, what is the interpretation of the word only? Only on religion, only on caste, only. My lord, just have a look at Article 15 for a moment. And if you see regulation, the one that is bothering my lord, see, it's a lifting of Article 15, putting into C. Exact language. There shall be no.
Only,
we fail to understand when 2C is already ingrained into E, why it is called out as a separate definition clause. And madam, please have the patience. If, as you may say, that it reflects the constitutional permission under clause 4, how?
No, my lord, under clause 15(1), there shall be no discrimination based on caste alone. And the language used in caste-based discrimination is alone.
That's
Caste alone. What meaning are my lords going to give to the word alone?
Unfortunately, caste, it's not the question of caste alone in the itself. It's only gender, it's
The Honorable Court possibly says larger includes smaller. That's.
Well, Lord, it is like saying these rules of interpretation do not apply to constitutional issues. Larger includes smaller.
That's what your lordship is saying.
Well, Lord, this is about the vision of the constitution and inclusive society. Let me put it that way.
Madam, we would have understood a vision if it serves the purpose for which regulations are made.
Yes.
What are the impact of the regulations? That is essentially in regulation 8 as to aggrieved persons, or regulation 7 with regard to measures for non-discrimination transport. Madam, allow us to conclude.
Well, Lord, it's a legal question which I will answer, which I'm duty bound to answer. What is the interrelation?
No. We will hear you, Madam Indira. My brother has posed a very important question, and it's not one question. There are 4 or 5 questions which arise for consideration. This otherwise this will have very sweeping consequences. It will divide the society. It will lead to so many very dangerous impacts.
I see the concern, my lord, but with respect, if you give me an opportunity, I will try to convince you it will not. It is a constitutional question which I am duty bound to address.
We are duty bound to hear all of you, ma'am. We will hear you definitely.
So, my lord, the interrelationship between the definition of discrimination and caste-based discrimination requires your lordship's interpretation.
That's it.
As to exactly how do these two interrelate with each other? Who has a remedy for a grievance? What is the nature of that remedy? I will convince you on these issues to the best of my ability.
Second, the extent of discrimination is reduced by excluding ragging. Why?
Yes.
My lord, there are, no, with respect, my lord, there is a 2009 regulation dealing with ragging. Which has been in existence for the last 10-15 years.
But it will become.
Passed on orders of this court.
I think they have, unfortunately, probably some of the aspects they have overlooked. We do not know who are the.
Look, this is like saying a full-bodied, a fully able person should get the benefits of disability discrimination. It amounts to that.
Young man, 19th March is the date?
19th March.
19th March.
Notice returnable on 19th March 2026 on our asking Tushar Mehta, Learned Solicitor of India, accepts notice on behalf of Principal number 1 and 2. Mr. Since the issues raised in writ petition civil number 101 number 1149 1149 of 2019 shall also have bearing on the while examining the constitutionality stroke validity of the implemented regulations, this writ petition, these writ petitions are ordered to be heard along with the above mentioned writ petition, So, meanwhile, the 2026 so regulations be kept in abeyance. However, the 2012 regulations shall continue in force so that the complainants are not left remediless. Next paragraph.
My lord, with respect, my lord, the stay of the regulations is not called for, my lord. At this stage, without hearing us. It's 19th March is not far away, my lord.
We will, on 19th March, you, please, meanwhile, you also file, Mr. Mehta, your whatever response, we would like to know that.
I know. But not with great respect, stay of the regulations will create a lot of problems. Your lordship wants social
we are
cohesion.
saying 2012 regulations.
We also don't want law and order on the streets, my lord. We are already seeing law and order on the streets. But my lord, law and order can come from anywhere. 34, 35 and 45. Law and order can come from any. Item 34, 35 and 45. Not take responsibility for it. This can't happen. You generate a law and order problem, come to court and get a stay. This is not right.
The complainants or victims can't be remediless.
But where are they? They are not remediless, my lord. They are not remediless.
2012 will continue.
Not remediless, my lord. I will tell you, they are not. Very well, lord, your lordship can do this. If they have any complaints, let them file the complaints. Let them file it. To that extent, your lordship may say.
We are talking of the complainants whom you are representing.
But my lord, may I just make a suggestion if it meets with your approval? If the concern is they can't be remediless, pending the 19th of March, when this matter will be heard, if there are any complaints which people from any quarter, any caste have, let them file it under these regulations.
No. That is not going to serve the purpose. That will create lot of complications, Madam. We are only concerned. We are not concerned about the general category complainants. We are right now concerned about the candidates who are marginalized. That their complainants, their redressal system should remain in force.
That's right.
So that's why we are saying that 2012 regulations will continue to have.
Look, they've been repealed.
My lord.
They've been repealed and superseded.
We are saying today, that in exercise of our powers under Article 142, we further direct that the 2012 regulations will continue in force till further order.
So great. Very well, my lord. Very well.
My lord,
Don't make political issue. We are again warning, we are only examining purely constitutional issue. If you want to assist, you assist. Otherwise, Madam Indira will assist us. Mr. Solicitor General will assist us.
I am appearing in item.
Yes, sir, will assist as a constitutional issue.
Thank you very much. Thank you. Thank you very much.
I am appearing in item 45.
On the next item, formulates.
Which has the same issue.
Well, first matters will come before us. We will tell you those. What is the
My lords, my matter is listed in 45.
Only one.
Don't file many writ petitions. Again, we are suggesting you. We can't stop you. That is not. We don't want to stop you, but don't file multiple writ petitions. If you have additional issues, you can move an application in the one of these writ petitions. Don't create a problem for us that we are unable to, because we have to decide the matter at the.
My writ petition is listed as.
Already before your
My
lordship.
lords, my writ petition is listed as item 45.
We have three matters are today. We are issuing notice in all three matters.
So grateful.
We are listing, that's why we have used the word these writ petitions.
So grateful, so grateful.
So grateful.
Don't be.
Not only one thing, I clarified, I didn't say voice, I said vociferous, means emphatic.
But my lord, I take it as a compliment, no problem.
It was a compliment. It was a compliment. I didn't say voice, she misunderstood.
No, my lord, I did not misunderstand. I take it as a compliment. Thank you very much.
Your lordship may only.
My lord, no, it would help greatly.
Die number
My lord,
5776.
it would help greatly if on the next date of hearing, your lordships formulate certain questions of law which you want us to address.
मेंशन कर रहे हैं तो ऑन कर दीजिए
Suggested questions.
Very
well, my lord, I will draft some issues for your consideration.
Can I mention item 37?
30.
I'll come to you.
Lord, lordships are in the parted bench.
Can I mention 37? This is that. We will just take up 37 also, Mr.
Because there
That is a Punjab Kesari matter. Item 36. Item 36. Right.
He's following the cases, right?
Bar Council. Because Bar Council will there was a direct.
My lords, I am appearing for the petitioners, my lord.
Anyone for appearing for the Bar Council of India?
No,
My lords,
although.
you can say, वो जो committee हमने बोला वो तो Delhi वाले नहीं है अलग से.
I think we'll see.
Anyone for the Bar Council? 2 elections every day are enriching our knowledge on election law. Maharashtra Gram Panchayat and the Bar Council.
My lords, I will serve them. My lords may keep in tomorrow or Monday.
All right, just a minute. The instant writ petition has been filed seeking a direction to constitute a committee for conducting the election of the Bar Council of Rajasthan. Having regard to the nature of relief sought, we do not deem it necessary to issue notice or to seek any counter affidavit. Suffice to say that certain committees were constituted by this court by order dated 18th November 2025 for conducting elections of various state bar councils. So one of the committee in that order at serial number capital B in bracket is the high powered election committee constituted for conducting elections in phase 5 Roman 5B. One of that committee headed by Justice J.R. Midda, former judge of Delhi High Court, has been constituted to conduct elections in phase Roman 5B. So that very high powered election committee also conduct the elections of the Bar Council of State of Rajasthan.
My lords, there's one more issue if I may address on it. My lords, the order said it has to be concluded by 15th of March. till date, the schedule has not been published. Therefore, they will have to modify my lord's order of.
They will not do anything. They will not do anything.
My lords, they will have to modify my.
Thank you very much. Thank you.
Great.
Next item 37.
This is the matter. We went back to the High Court.
Yes.
The High Court not has not decided on merits. They said you go in appeal. So appeal also doesn't lie.
Appeal lies.
Doesn't lie in several
It
matters.
lies under the Water Act.
No, it doesn't.
It lies under the Air Act.
It does not.
It does. And under the EP Act.
You have a statutory alternative available.
No, my lord, that's not correct. My lord, the action is under three sections. Action is under three sections. 31A, 32 and 33. Some are appealable, some are not appealable.
Both, all three are.
If you don't mind, can I just complete, please?
To file appeal against all actions.
I can't, because I cannot. There is a
We are
specific.
permitting you, will permit you. The only thing is that you will not, as far as newspaper is concerned, you will allow to function.
That's right, my lord. Lordship said past and.
That order is already there, my
No,
lord.
my lord, I wish to submit, my lord.
That can continue, my lord.
That's right.
No, that's fine, my lord. Hotel is closed. Hotel will remain closed. I have no problem.
The hotel is-
Insofar as the press, I want to show you, my lord, that, my lord, it is not appealable. I want to show you that.
No, we will say that, that they will not raise any objection of maintainability. of
Under the section, my lord,
That the appellate authority will entertain the appeal and decide.
no, under the section, it doesn't lie. This question has been,
Wherever you see, you have multiple causes, right?
yes, yes,
Some of the causes are appealable.
Yes.
Some are not.
yes.
So the principle of, there is no.
I understand, my lord, I understand. They only answer.
Claim.
They only answer, my lord, half a second. My lord, this question arose, my lord, in Sterlite's case. Exact question. Some appealable, some not appealable under these provisions. The Supreme Court said that those which are not appealable and which are appealable, the only recourse is the petition under 226.
Doesn't matter. You can go to the NGT.
That is what the Supreme Court said in Sterlite. I am only telling your lordship, my lord, I can show that. That if it is so and questions, my lord, of malice.
No,
in-
it's not.
my lord, in-
Even assuming that there is an alternative remedy, nothing precludes the High Court from entertaining.
That's the second point.
That is, Mr. Rodriguez, that's the prerogative of the High Court.
My lord, the third point. This is the case of malice. There were 12 raids in 3 days. No hearing given. Without inspection, FIR.
Therefore,
This is what is happening.
why don't you go to NGT in Delhi?
But my lord,
Independent.
the NGT can't decide the factum of malice. That within 3 days you have had, my lord, 12 raids. My lord, you have had FIRs. My lord, you have stopped my transport, my lord, of newspaper. There are so many. I have made out a list. My lord, what we have done.
Based on this.
Kindly have a look.
Against all three acts to file the appeal, Lordship.
Sorry?
And moreover, if they are not going to the proper form, Lordship,
I have ETP, my lord. I don't require statement.
if they are running a media house, whether they are Baba
Not a sewage treatment. I require
was taken to cure their defects till date, Lordship.
ETP.
All were non-functional.
Proper form is NGT, they have to go there.
Hotel is closed. I'm not on the hotel for the time being. Just have a look at this.
In a hotel.
How do I argue this?
All the orders are applicable, Lordship.
No, not at all. Manoj, may kindly see the no opportunity
I understand.
authority which is passing the order is not the competent authority. The jurisdiction lies with
Number one.
the chairman, and the order is passed by some environmental
Hold on,
engineer.
please.
Manoj.
Just a minute, please. As regard to the hotel party,
Yes.
we grant you liberty to seek any internal direction before the NGT.
Right.
3, we will request the NGT to entertain
Yes.
comprehensive appeal on all the issues, even expressly, even if
All
implicitly,
right.
there is no jurisdiction conferred.
All right.
We will also now, because they are taking objection, so therefore they will be restrained from raising the objection that it is not maintained.
We will not.
Appeal will be maintained.
But without for
Fourth, it's a composite fact we are doing. Fourth, we will request the tribunal to decide it in it.
Sir, I would respectfully submit the first, what your lordships are saying, the chief justice should be, my lord, related insofar as hotel is concerned. This is a normal thing. But insofar as, my lord, the press is concerned, I have a host of things to, my lord, argue and show you. Malicious. Inside malice, my
You
lord.
don't have a consent to operate in the place.
No consent to operate. Just, please, my lord, please keep it tomorrow. I will show you that the law says, even if you don't have, even if you don't have, the law says they will ask you to comply and will not close you. Somebody has to look at it. They passed an order, High Court says, I will not look at it.
On
It's
that-
now a first appeal. Allow me to show you the provision. The law says even if you don't have, you can carry on and they will ask you to will not do the requirements. I want to show you that. Just have a look, Milord.
There's also a provision for emergent situations.
Correct.
Correct. Now the emergent situation is, Milord, to carry out operations. Emergent situation is not to disconnect.
Chaudhary, there should not be any difficulty for you in approaching the NGT.
Correct. Can't be.
Milord.
Also, we have permitted the printing.
Look at the nature of the violation.
It is suspended the order as an interim measure.
Right, right.
With regard to the printing press.
Right.
So you are not worse off if you go to the NGT with regard to the printing
Only,
press also.
I'm not worse off except that I can't argue without issues of
Suppose
Alice.
with regard to hotel,
Yeah.
hotel part, suppose they comply with everything. Report to you that yes, they have everything, STP, but etc. those have been installed
Yeah.
and all the measures have been taken.
Yes.
You can send your team to inspect.
Yeah,
re-inspect,
decision will have
and
to
if
be
compliance is.
Milord, I have no problem. They can come and inspect, Milord, on Monday.
But if they are filing.
Problem is, Milord, you go on one day, you look at this and give you an order, Milord, of 2 pages. They don't look, they don't listen. I want them to come.
Lordship, in both the organization, there is
Please come
no
to the hotel on
government
Monday
consent to
and see.
operate the
I
organization.
respect, Milord.
by the petitioner.
Valid consent.
Milord, I wish to submit, Milord, an officer of the CPCB should also be a part of the team. Because we have a problem with this state, we have a problem with this
Why
authority.
should they do that?
Please make CPCB a
Lordship,
part.
that,
Let the
Lordship,
CPCB come.
these are the false allegation.
This is something, Milord, this impinges on 19(1)(a).
To
Yeah.
constitute a team,
Yeah.
because they have a panel of experts always.
Yeah,
Request them to send a team
no problem.
and to submit a.
All right.
Let them
And
take
for
it.
both, Milord, I will go to NGT
That
as the
is
Lordship
not-
says.
They have to go to the NGT. in
And
a
the
week.
press goes on and Milord,
They have to
the Lordship
go
may
to
appoint that,
NGT.
That we will, the specially petition directed against, these two specially petitions are directed against a judgment dated 23rd January 2026. Passed by a division bench of
this is fine.
the High Court of Punjab and Haryana, whereby the petitioners have been relegated to avail the alternative remedies either under the statute itself or under section 33 capital B in bracket small c or to approach the National Green Tribunal under section 33 capital B in bracket small c of the Water Act. Next paragraph. We have heard learned senior counsels on behalf of the petitioners as well as learned senior counsels along with Advocate General and Additional Advocate General on behalf of the state of Punjab and its authorities.
And the pollution control.
In our considered opinion,
The pollution control board.
on behalf of the State Pollution Control Board. In our considered opinion, there is no need to interfere with the implaint order of the High Court to the extent of relegating the petitioners to avail the alternative remedy. However, certain clarificatory directions are necessitated. However, the following clarificatory directions, in the peculiar facts and circumstances of this case, are necessitated. 1I, the petitioners may approach the National Green Tribunal, if so advised, at the earliest, along with an application for interim direction. 2I, in view of the categorical stand taken on behalf of the petitioners that the hotel has already complied with all the norms, including the STP, etc., ETP, requisite ETP, etc., the petitions may request the National Green Tribunal to constitute an expert team to visit the site where officers of the State Pollution Control Board may also be associated. The joint inspection report and or the separate reports if submitted by or the separate reports that will be submitted by the State Pollution Control Board and the expert committee constituted by NGT. The tribunal may consider the prayer for interim direction. It is clarified that we have not expressed any opinion on merits of such prayer. Next paragraph. Till further orders are passed by the NGT, the hotel shall remain sealed. However,
Status in respect to the hotel may continue.
the hotel shall remain non-functional. The hotel shall remain non-functional. Don't say sealed. However, the directions issued by us on wide order dated 20th January 2026 with respect to allowing the printing press for the publication of newspaper Punjab Kesari to function uninterruptedly, shall continue in force, and thus the newspaper shall be allowed to be published uninterruptedly without causing any impediment. Without causing any impediment.
The interim application is decided.
Till the matter is decided by the NGT. Not only one thing. Subject to the final order that has been passed by the NGT.
Now, my lord, as far as the hotel is concerned, hotel is closed.
The application is decided.
Now, I want electricity to be reconnected, not for, my lord, the hotel to run, but, my lord, for these plants to run to show. Otherwise, I can't show anything.
That has to be clear. That has to be done before the
Not my
NGT.
statement, that the hotel will not be occupied.
They have a generator.
It will not be occupied, my lord, till further order. But
If you only want to submit one thing, Lordship, my lord, may kindly direct to the petition.
A restoration of electricity supply, power supply for the limited purposes.
Yes.
For the limited.
And the record man will take it, it will not be occupied.
And subject to such conditions as it may deem appropriate to be imposed.
Lord, your Lordship, kindly say that the interim orders, interim applications will be decided within a timeline. Otherwise, my lord, they can take their own sweet time to file an appeal.
They will file the appeal on Monday.
Let the interim application be decided
within 3 days.
1 month.
Why should I not file an appeal?
We request the tribunal to decide the matter expeditiously.
Very good. Very right.
Your Lordship, may I just.
43, my lord.
30, my lord, item 30.
Item
It's that widening of road to reach the hospital. Lord, that item 30, widening of the road to reach the hospital. Hospital, my lord, we could not open, only OPD is open because ambulance, etc. cannot go. So that may be kept on Monday, my lord. Possibly bench is not available tomorrow, I'm told.
Let's sir. Item 43, the interim order direction with respect to Tamil Nadu.
Only a minute.
ECI.
Mr. Elango.
Next Wednesday or Thursday.
Your Lordship, may I just, item 43.
Wednesday or Thursday.
Lordship, may I just, item 43.
Sorry.
Yesterday, Lordship, we were pleased to say the directions issued in West Bengal.
Well, Mr. Naidu had said that he'll come
43.
back with instructions.
Just a minute, sir. Just a minute. Wait for a minute, please.
Mr. Sibal is there also.
Item 42. Item 42, yes, issue notice. Transport, issue notice or returnable on so date. Meanwhile, the proceedings in session trial number 5794 of 2025 in bracket State versus Satyavan arising out of FIR number 383/2025 under section 124 in bracket 1 BNS 2023 dated 6/8/2025 shall remain state. The
Lordship, the accused is the father. Accused is the father here, and the victim is a minor.
42 says that.
And there is a clear threat to her life.
Can you serve the Dusty? Can you serve Dusty notice?
We're not there. It's under trial in the ASD of Bhiwani, Haryana.
You serve through Dusty notice that may be served on the counsel representing the accused before the trial court. And state of Haryana के लिए बोल दो उसको additional additional advocate general will have instructions in the matter.
Mr. Singhal is the.
So from victim's case, any other protection you require right now? Transfer we have issued notice, we can't transfer without hearing the accused. Just keep ready whatever the additional directions that may be required to be issued on the next day. Okay. Yes, item 27. 27.
Item, mentioned item 32 minutes.
27.
27 minutes, Mr. Rothgi is leading me.
Yes.
Yes, item 39.
This is the same matter Lordship had requested the Honorable High Court to decide. Milord, this is a case where accused pretended that I was married to the accused. On that basis, he got a stay on the trial, Milord. I approached this Honorable Court, Milord, and this Honorable Court directed Honorable High Court to decide the matter expressly. Now, Honorable High Court has recorded in the order, Milord, I am carrying that order, that accused had obtained that order on stay of trial by playing fraud on the court, Milord. And similar fraud he played while seeking the bail in these two matters, Milord.
If you have to go and explain there what the...
Now, Milord, unlike the previous case in which there was an interim order and this Honorable Court directed me to go back, this is a final order of granting bail, Milord. This requires consideration, Milord.
No, where is the question of grant required consideration? Who is the petitioner before us?
Milord, I am the petitioner for the Lordship.
11 more, 31 days. There will be 11 more days.
The other matter is well.
Any returnable date?
What is the date in the other matter that was disposed of?
That was disposed of, Lordship.
Your Lordships, I am for the state in this. In item 39, Your Lordship.
Then she accept notice on behalf of the state.
Just
Congratulations, the other accused respondent hoga that remove yourself through dusty notice through the local council. Or through rather, if you are the state is there, then you ask your SHO to serve. At the SHO of the local police station shall ensure that the service is effective in the accused. Yes, item 40.
Deeply obliged, Lord.
These are arising of the alleged whole scam in which my lords was pleased enough to grant regular bail to yesterday, my lords. I am praying. On third, similar matters are coming up straight.
Right, Lordship, I just mentioned that in respect to UGC matter, there is a fresh matter also which was there, Lordship, but unfortunately.
Item, which was any other item? Your item?
Item 37 may take time, my lord. It may be 27, my lord. Item 27.
27, that acquisition.
Yes.
Lord, Mr. Rothgi is leading me for the caveator.
Maybe on some date, my lord. Maybe
next Friday, my lords, in case it is. Just next Friday.
This matter?
Any day.
After 2 weeks, my lord, some Monday or Friday, my lord.
Well, 13th February.
Right.
Yes.
That
32
Lordship, tomorrow. There was a fresh die number also is to be included, notice to go in that also.
Lord, item, Lord, can we have it Monday after 13th?
That will take up 140 days.
Yes.
We will take up at 2 o'clock only for the limited purpose of fixing a date for hearing. And you tell us that how much time will require, or you want, we can fix right now.
Period number 21. Period number 21, there are a whole list of matters where compilations are made before courtroom floor. Now, I am not aware, my lord, whether they are all here, they are not here, I don't know.
No. Wherever the matters are there, we will hear this matter. This, otherwise, every day the petitions are coming, matters are coming. Already we have 1066 matters are listed.
About 500 more, which are not here.
800 today.
And more than 500, 400, 500 matters are in pipeline. So this floodgate has to be stopped by deciding this. There is an interesting question of law.
Lord, we are appearing for the petitioners in this batch, my lord. We are also ready for the hearing, my lord.
So we are fixing the date. We can take up on 13th. No, not on 13th.
The end of this February, your lordship.
Are you ready to argue on 10th February?
A little later, my lord.
Later, I'll
All right,
just,
all right.
my lord, may I just
Maybe-
explain?
All right, what about 17th February?
My lord, some date earlier in early March,
Seven-
all right? 18th.
No, please, February, March, we are starting a constituent bench.
End of February, your lordships may have, my lord.
17th February or maximum we can accommodate you on 24th February.
Very well.
Make a choice between 17th or 24th.
Whatever, my lordship,
20
may I just request early March if it's feasible. I'll just tell you why, my lord. What is happening is, there is one issue, my lord, which is of 151A, which is the main issue in terms of ex-aware which has all been brought. Now, along with that, my lord, there are a series of 6 or 7 other peripheral issues which are there, some of which are before your lordships and other benches.
No matter before any other bench.
Other issues, there are matters there.
Other issues, matters are there. We are aware of that. Please have that much trust in me that I know about all the matters pending. What are the points involved?
My difficulty is disposing of. You know, what will happen is the petitions may not be
First
disposed
issue,
of.
the first issue, this matter, we might decide this question of law.
On 151A. Yes, I have.
That will be the second phase.
Yes.
That will be the second phase. If you are agreeable to hear this matter on 17th February, then the other issue we can take up on 24th February.
Your Honor, in some of the matters under Rajiv Bansal, there is a concession made by the department and some of the matters fall in that. So the department can give us a list, lordship, that these will.
No, don't worry about the department's list. You argue simple, the only one question of law is there.
Yes, my lord.
Except irrelevant.
Yes, XFI has to be taken out separately, my lord. There are 7 other issues. All other issues involve only one question. We'll give that question alone. Who is the authority to issue notice? Yes.
151A really is the major issue. Your lordship feels, keep 17th, my lord, I'm.
17th February, and give us a brief note from both sides.
My lord, we will do that. Compilations and papers are filed. They are filed in XOL, subject to orders of the court.
But just check up whether the communist compilation is there or not. And you can give otherwise a brief note of submissions and approximate how much time from petition side you would like to have.
My lord, we are respondents.
How you are the respondent?
We are the respondent.
Mr. Venkat.
But we will take about 2 hours. We have 2 hours from our end, my lord, we'll complete it.
2 hours. All right. You also may require 1 hour at least.
Require more. You will require more, my lord.
No, please tell us because so that we can have an.
It will require at least 2 hours.
We'll complete it. Not from our end, we'll take 2 hours.
There will be no curtailment as such. We only just want to have so that we other matters we don't be in getting. So 2 hours we'll give to Mr. Venkatraman to you and 2 hours to the respondent side.
Item
43, symbol is there, my lord.
Item 43, Mr. Naidu had said he'll come back.
Item 47, Lord. SIR matter, item 43, Lord.
What date you want in the other matter?
Lord, item 40, there was an urgent relief which was prayed yesterday, item 40.
Let us know the date.
SIR,
Lordship, in UGC one, there is a one more die number which let notice going that also. There is
my
one-
lord indicated, therefore listed it.
Symbol is there. Item 27 requesting for.
हो क्या रहा है? We'll mention it again at 2 o'clock.
Plus, may I
Yes, sir.
mention item 32 listed at court 11 tomorrow.
Lord, item 43, the Tamil Nadu SAF matter. Yesterday, my lord, sir, please to observe that the whatever order passed for West Bengal is to be applied. Mr. Sibyl is online, my lord.
We don't require Mr. Sibbal, we require Mr. Naidu.
Next in court 14, my lord. He'll be here, my
Lord,
lord. This matter will be taken up after the ADR matter.
He will be here after some time, we'll find out.
Lords, may I mention item 32, my lords, listed tomorrow before court 11. Because we had filed an intervention application yesterday, my lords. It's not on record. We had refiled it within time, lord. There was a slight technical issue. I was still not on record. We had mentioned before court 11.
What are you mentioning?
My lords, this is an SLP challenging a high court order where an FIR was quashed. Now, that order has been stayed. However, respondent number 2 to 6, the private respondents have an order of no coercive action to be taken against them. Now, the IU is initiating proceedings against us. We are a partner of that, of respondent number 2 partnership firm. And he's issuing letters against us, impugning us in investigation.
We can't understand such a lengthy speech on mentioning. Please start, we'll start.
Yes, 7, may I mention, but for a little change of date, Lords, I have informed the other side, Lords.
I approve for the petitioner, my lord.
Lords,
So,
Lords, 13th as the date.
No mentioning it, they're free for all who have
The IA may be taken on record is my limited prayer.
Thank you very much, no mentioning.
So, Naidu is here. Have it on.
Lord, Mr. Naidu is here. Mr. Naidu is here in that.
Mr. Naidu.
Yes.
Tamil Nadu.
Yes, please, I'm coming.
We can't discriminate between state and state.
My lords indicated yesterday. Now, I believe it's role reversal minutes. I requested your lordship's permission to appear online. I cancelled my program. Mr. Sibal seems to be suffering from viral fever. He is online. Role reversal minutes. Minutes, your lordships indicated, after all, they are asking what had been given by your lordships in the case of West Bengal.
Small procedure.
Kindly have a look at it, minutes. That order.
So wherever West Bengal, where there will substitute with Tamil Nadu.
And one issue is there,
If there is any.
even in this order also, minutes, now ECI has filed an application for modification.
This need not be given that. We don't know. Para 10 definitely will not apply.
Thank you, Lordship.
That Madhyamik issue.
Yes,
that will not apply.
will not apply. Kindly come to para 4 minutes. Kindly come to para 4. My lords could see the first one. The names of the persons figuring in the logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places, etc., etc. My lords, it's perfectly in sync. Nobody can have any grievance.
Yes, sir.
So is the case with.
In fact, this came from your side.
Only third one, my lords. My lords may kindly come to third one. Documents, objections may be permitted to be submitted at the Panchayat bounds or block offices.
That may create problem. Panchayat will may create problems because then you have to have additional manpower even to, that is understandable. Ye mistake hua hai.
And we have filed an application for modification in this order also, my lord, that is set to be listed. The logistical problem, nothing else.
Block level you can do it.
Yes. I believe, my lords, the expression is different in Tamil Nadu. It's not block.
That can be, that's very small.
No.
It is taluk.
Otherwise, what will happen?
Yes.
Your employee only will have to be again deputy.
Yes.
So why to have unnecessary burden on the employees and state?
Yes.
So let's say this, is there any application filed by?
Yes, sir. RS Bharti.
RS Bharti petition.
IA 25152
of 2026. 25152 minutes.
Say, we have heard learn senior counsel for the parties in support and against the trade medicines application. The issue in the main case pertains to the ongoing special intensive revision of voter list in the state of West Bengal or in the state of Tamil Nadu. Approximately how many voters have been issued notice?
Notices not as on today, 1 crore and 16 lakhs, 69,860.
Notices have been issued
Pending.
approximately 1.8
1.16 crores.
16 crores individual for the purpose of for the purpose of verification of documents. These notices, are broadly categorized in 3 groups. That is, 1I, map, as the category of voters are linked with the 2002 in Tamil Nadu also 2002.
Yes, Malas, 2002.
To SIR, 2I, unmapped, dash the category of voters who are not linked with 2002 SIR.
2002 and some places 34 constituencies or 2005.
It was in 2002. For 37 assembly constituencies.
2005.
2002 or 2005 SIRs, as the case may be.
Yes.
1I may be, 2I may be, dono. The third category involves logical discrepancy. Involve the individuals who have been included under the head of logical discrepancy.
Yes.
Next paragraph. Having regard to the experience, the difficulties being experienced by the people in state of Tamil Nadu, we deem it appropriate to issue the following directions. 1I, the names of the persons figuring in the category of inverted commas logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places, public offices, and taluka/block offices of every subdivision, including the ward offices in the urban areas.
May I say one thing? In Tamil Nadu, there are no blocks.
Taluks.
West Bengal, there are taluks. Panchayats, then taluk. Block may be, that reference may be
in every taluk, that is in bracket subdivision. 2I persons likely to be affected under the category of logical discrepancy are permitted to submit their documents/objections in person or through authorized representative. Within a period of 10 days to be counted from today.
Malas, I'm sorry to interrupt, Malas. May I just, with your lordship's permission, Malas? The logical discrepancies that they mention, Malas, they don't give us what the logical discrepancy is, because it was mentioned.
Once it is displayed, then every list will have to be.
They don't. They haven't done it in West Bengal. I've seen it myself. Kindly put that in, Malas, because we don't know what is it that we need to clarify.
I think we have seen it, Mr. Sibal, in West Bengal also. There is a mentioning that whether parents' name.
No, Manas, they haven't. Next West Bengal is coming on Tuesday. I have the chart. Manas, they don't mention anything.
10 days from the date of displaying the list of persons falling in the category of logical discrepancies. Such lists obviously will contain the brief reason of discrepancy.
Obliged, Manas, obliged.
Next, the documents/objections may be submitted in the taluka level offices, taluka in bracket subdivision level offices.
One more prayer. Or through the BLOs, or through the BLOs, their representative.
No, but BLOs will be your representative.
No. BLA is my person. BLO is by the election.
May be submitted to the BLOs in the offices of the BLOs or at the taluka level offices.
Greatly obliged.
Then next main paragraph, the Election Commission of India This 10 days we have already provided. Next, for the state government is directed to provide adequate manpower to the Election Commission of India and the State Election Commission for deployment of personnel at the BLOs or subdivision in bracket taluka level offices to handle the document stroke objections and hear the persons likely to be affected. In this regard, we direct each district collector to meticulously follow the instructions issued by the Election Commission of India for deploying the adequate staff and forces for the smooth functioning of the functioning of the SIR process. Next paragraph. The Director General of Police, Tamil Nadu, former Superintendents of Police, Superintendent of Police of each district, and the collector are also directed. Are directed to ensure that there is no land order problem, and that no law and order problems are created at the above stated locations. Put it positive, will ensure that law and order is well maintained and the entire process is allowed to function smoothly. Next paragraph.
That direction may not be required for Tamil Nadu. If there was no
complaint to that effect.
Yes, because we are maintaining same parity. The affected persons, besides an opportunity to submit documents, stroke materials or objections, may also be heard either in person or through the authorized representative accompanying them at the taluka level office. The hearing should be there only because they are responsible.
Yes, sir.
At the taluka level office. The next one, the official who will receive the documents or accord the hearing to an affected person may certify the receipt of such documents and the conduct of hearing.
Obliged.
Other direction is not required.
That will be required.
The agent would include BLA 2 that your lordships may observe, because here it is said at para 2, subpara 2.
An authorized representative or that may include BLA.
Yes,
that's right.
Yes, grateful.
Deeply obliged.
My lords, I'm just appearing in a connected petition, WPC 1145 of 2025, same order, ma'am. Same order. That's colonial.
Instead of repeating the order, mention on the top both the matters.
Veera Pandian versus Election Commission.
May I make one submission, Smils? With regard to other states also, the same thing may apply. Your lordships may pass sort of an interim order.
Where?
If my lords have given the conditions now, it may apply across the board wherever SAR is there.
But I think they
So
should
that
be
it will save judicial.
I think Election Commission should implement instead of people coming and Mr. Sibal even while down with fever making so much energized hearing and
it can be directed.
Like उसमें एक जन ये कर देना we expect that the Election Commission of India will ensure compliance of these procedural directions in all the states wherever the SIR process is ongoing.
Great.
Grateful, my lords.
Lords, in item 27, Lordship, Mr. Rohatgi was leading me. He requests for change of date. 13th February, Lordship has fixed. We are requesting for 16th February.
Date के way mention you give us the slip. We will give the date.
I had requested 16th February.
Yes, Mr.
My lords, one more submission, please. My lords indicated reasons must be specified, displayed rather. Some of them may be matters of privacy minutes. When we issue notice, we specify all of them in the notice. I'll tell one example, Millets. If father is 70 years, son is 20 years, we just say it's logically.
That's it in the notice.
Those things we inform them. So they did not be displayed.
Along with brief reasons that may be mentioned in the notice.
Great.
May it please your lordship. Before learned friend starts, my lord, apropos what fell from my lord Justice Bakshi yesterday regarding Aadhaar and passport note, I prepared a 2-page note distinguishing between them, lord. Can I just hand it over to your lordship, my lord?
So, my lord, yesterday, Mr. Yogendra Yadav pointed out that there is a structural problem with this SIR or the manner in which this SIR is being done, which has led to one substantial reduction in the number of voters as compared to the number of adults in the constituency. And number two, in the percentage of women voters versus percentage of men voters. Now, the reason why this structural problem has occurred with this SIR is because, my lord, in this particular SIR, they are trying to prepare the voters list de novo on a clean slate, so to say. This has never been done. There was an earlier SIR in 2003. That SIR did not seek to create a voters list de novo. The reason why this structural problem has arisen is because in this SIR, they have placed the onus on the voter. So they are saying, firstly, you have to fill up this enumeration form. If you don't fill up this enumeration form, you are out of the roll, you are out of the draft roll. Number two, you have to provide these documents. If you don't provide these documents, then there is a problem. Earlier, when the SIR was done in 2003, there was no de novo voters list being prepared. The existing roll was used as the base, and the ERO or the BLO went from door to door, finding out from the people as to who are the residents in this house. That's how, my lord, that SIR was done. And this structural problem of reduction in the percentage of voters compared to the percentage of adult population, as well as the reduction in the percentage of women voters, has occurred precisely for this reason, that when you place the onus on the voter to first fill up the enumeration form, and if he doesn't fill up the enumeration form and doesn't provide those documents, he is out of the electoral roll. And then what happens is, my lord, that many people, especially those who are weaker, and women, my lord, in our Indian society are weaker, and therefore many of them are unable to fill up the forms. The migrant workers who may migrate for work during some time and come back, etc., those people are also not able to fill up those forms. And that is why the structural problem has arisen. So that's the first point, that never earlier, except when the first voters list was prepared, a de novo voters list has been attempted to be prepared, except in the constituency of Thakur Dwara in UP, where, my lord, they recorded elaborate reasons, Election Commission recorded elaborate reasons as to why there is a serious problem with the voters list in this particular constituency, and therefore we want to prepare a de novo voters list in this particular constituency. Otherwise, never ever in the history of this country has a voters list been attempted to be prepared de novo, and especially in such a hurry as it has been done in this particular SIR. It's been done in an unseemly hurry. In Bihar, one could have understood that your elections were 3 months away. Of course, you should not even have attempted this SIR 3 months before the election, but you wanted to do it, so you did it in 3 months, etc. But what is the reason for doing it in this unseemly hurry in the rest of the country? Even if you want to prepare a de novo voters list. Secondly, my lord, the argument of the Election Commission that 324 is a carte blanche to us to act in any manner that we want. We are not bound by any law made by Parliament under 327. We are not bound by any rules. We are not bound by our own manual that we can do what we want. that this is a carte blanche to us to do what we want, how we want. Lord, this argument cannot be countenanced because no authority can act arbitrarily. No authority can say that there is a law which has been framed by Parliament on this, but we will not abide by this law. No authority can say that we will not abide by the rules. No authority can say that we will not even abide by our own manual or our own guidelines that we have issued earlier. And especially without any good reason. So therefore, Lord, this is a serious problem with the manner in which this SIR is being done. And that is why those structural problems have arisen, which had never been done like this earlier. Then, my Lord, on the issue of citizenship, I'm not going through everything, I'm just going through some. On the issue of citizenship, my Lord, of course, the election commission or the voter can only be one who is a citizen of India. But the question is, how will the election commission or the electoral registration officer, ultimately it is the ERO who has to determine. ERO, if we give this power of determining citizenship to the ERO and we say, all right, he will determine the citizenship. How? So he says, all right, you show one of these documents. The only, as your Lordship was told, the only documents which are even prima facie evidence, even those can be wrong, are passport and birth certificate. The other documents are no evidence of your citizenship. So how will he show? If he doesn't have birth certificate or passport, how will a person show and what is the basis on which the ERO will determine your citizenship? And that is why, my Lord, for good reasons, the Election Commission itself in the 2003 SIR, in the 2004 Assam guidelines, everywhere they stated very clearly that, look, it is not the job, if your Lordship sees the SIR of 2003, which is, my Lord, in our written submissions which we had mentioned, in our or additional affidavit dated 8th October, page 47, and in that, my Lord, page 51, para 32, they say, this is the SIR of 2003. This is the Election Commission's own directions in the SIR of 2003. And this is what they say, and for good reasons they say this, because otherwise, my Lord, it will be an arbitrary exercise of power. It says it is clarified, para 32, page 51. It is clarified that it is not the job of the enumerator to determine citizenship of an individual. However, they have the power and responsibility to exclude any person on the basis of qualification for registration regarding age or ordinary residence. Age can be verified with reference to but not restricted to so-and-so. Ordinary residence must be checked with reference to all municipal panchayat documentation, ration cards, delivered mail and any other document such as gas connection, telephone connection, bank account, etc. Very wide, because, my Lord, the whole object was that the burden of proof of proving yourself to be eligible for the electoral roll is not essentially on you. The burden, if you show any document of any kind about your identity, your residence and this, and your age, that's good enough, any document whatsoever. For citizenship, my Lord, that form 6 clearly said that only a self-declaration, because what else do you do? If you don't have those documents, what do? You'll only make a self-declaration, and thereafter, my Lord, it is for somebody else to prove that you are a non-citizen. And that proof, my Lord, will have to be on the basis of all documentary and oral evidence, which is what Lal Babu Hussain said. You have to take every evidence, documentary or oral evidence. Suppose, my lord, I don't have documentary evidence. I give my affidavit that I was born here, I have been living here. I give my neighbor's affidavits that yes, we know he was born here, he has been living here, etc. That is normally good enough proof. If somebody wants to displace that, he has to show evidence to displace that and show that no, he was born in Bangladesh, he was in the voters list of Bangladesh, etc. And that is why, my lord.
How can that find out, Mr. Bhushan? That may be practically impossible. You can read evidence early understandable.
Yes.
That you don't have document, you produce your neighbors or maybe sarpanch or some respectable person.
Yes.
But how to find out that you were born in particular?
That's the point, my lord. So the whole scheme of the act and the scheme is that if you assert, Form 6 says that you only have to assert that you are a citizen. You only have to give a self-declaration. Of course, it says, the caveat is that if it is found to be false, you are liable to be prosecuted. That's all. Otherwise, it's only a self-declaration. Thereafter, my lord, somebody else. And that's why, how will the electoral registration officer, how will he consider, he is not a court. It has to function like a court. All oral documentary evidence, including cross-examination, if somebody is asserting something which is contrary to what I am asserting, I have to be given an opportunity to cross-examine him also. So therefore, that is why advisedly, the Election Commission repeatedly in the 2003 SIR, in the 2004 Assam guidelines, etc., they continuously said that, look, Election Commission, the enumerator should not determine citizenship. It should flag that issue and send it to the relevant authorities who will decide after consideration of all evidence as to whether he is a citizen or not. It is not for the Election Commission to determine the citizenship, because otherwise you are giving them an arbitrary power. And today, my lord, in today's date, where Election Commission has been accused of partisanship, it will be a very, very serious problem if the Election Commission is conferred with an uncanalized power to reject somebody on the voters roll by saying that he is a non-citizen because Election Commission, because he has failed to produce any document, because Election Commission doesn't believe that he is a citizen, etc., because it has very serious consequences, as in that case where the court has held, constitution bench has held that this is a constitutional right. The right to vote is a constitutional right. And you are taking away a constitutional right of a person, can't do it arbitrarily in this manner. And that is why, my lord, advisedly they said that. So that is so far as the issue of citizenship is concerned. Thereafter, my lord, and Lal Babu Hussain, my lord, basically said that the previous electoral, even if the Election Commission is to determine citizenship, it has to observe the following things. And that Lal Babu Hussain is not on the heels of any intensive revision as the Election Commission is trying to argue. Nowhere in Lal Babu Hussain does the judgment proceed on the basis that because there was an intensive revision here, therefore the previous electoral roll will have probative value. They say no. Number one, the previous electoral roll has probative value. Number two, you have to give reasons, you have to tell the voter why you are doubting his citizenship and give him reasons as to why you are doubting his citizenship. Number three, that the Election Commission must take all oral and documentary evidence, any evidence that that person may present for asserting that he is a citizen. Number four, that a speaking order thereafter has to be passed. And that is why, my lord, this is really the job of a court. And this is the job of a tribunal. This is the job of the government of India when it is deciding a claim under the Citizenship Act. It is not really the job of the electoral registration officer, and that is why they had been saying this. Now, my lord, coming to the other issue of transparency. Now, they say that we cannot give the machine readable voters list. We have been saying that let them at least adhere to transparency. If they are doing this exercise, let it be a transparent exercise. Therefore, at all stages, the voters list should be available, the original voters list, the draft roll, the names of the deleted people, the reasons why they have been deleted, and thereafter, every application, and that is provided in the rules themselves, in their own manual itself, that Election Commission has to put on their website every application for addition of names on a daily basis, every application for deletion of names on a daily basis, and every order passed by the Election Commission. And they have it on their website, they have it with them in their computer. Why can't they put it on the website so that people can see? People should be able to see it. It's not a matter, it's not enough for them to say that, look, we have been giving it to the BLAs of political parties, we have been putting it out in the Panchayat Bhavan, etc. That's not good enough, my lord. Because that's a disputed claim. Whether, firstly, my lord, BLAs are not the political parties are not the only stakeholders in electoral democracy in this country. The main stakeholder is the citizen. And therefore, the citizen needs to know, the citizen has to have transparency. Who are the people on the electoral roll? It should be searchable and machine readable. Because the argument that they are making that, look, if you make it machine readable, there will be violation of privacy. How does machine readability make it a violation of privacy? Machine readable only makes it easily searchable. And the judgment that they are relying upon, Kamal Nath, that judgment doesn't say that. In fact, that judgment says that the political parties or the people themselves can convert it into a machine readable form by using their own computer resources. That judgment only said that, look, this is the rule. Right now, we don't need to pass any direction beyond this. What we are arguing, my lord, this is a case which goes to the root of our electoral democracy. Do we have a voters list which is transparent, which is searchable, which is machine readable? Do we have applications for deletion and addition being put out on the website? And that is the requirement of in their own manual. They can't say that, look, we are an unguided authority, we can do what we want. Now we don't want to do this. Even though we provided it in our manual, we don't want to do this. Why? Why should it not be transparent? That's the minimum requirement. Then, my lord, they think that we can't use the deduplication software. Why can't they do it? Today, my lord, we have advanced far beyond. Earlier, when the election manual said that deduplication software has to be used to see the similarity in photo similarity and demographic identity. So you can remove duplicates by first flagging them on photographic identity and demographic identity. That means same address, same name, same father's name, or same photo. And thereafter you go and verify whether this person is there or not. Why can't that be done? Today, my lord, we are several years beyond that. Artificial intelligence has advanced much more. Artificial intelligence can be used now much better for deduplication software. Why should that technology not be used for deduplication, etc.? They are saying, they don't need to use it. And their manual talks about it directly. It says very clearly that deduplication has to be done by using this software. Then, my lord, social audit. Now, social audit is something which is provided again in their own manual. It says that electoral registration officer will go to the Gram Sabha, Ward Sabha, etc. Thereafter, he will first issue an invitation, call everybody, whoever wants to come for that exercise, where he'll call out the names. People will tell him, look, this person has died, this person has shifted out, this person is not here at all. That's the best way and the surest way of doing this intensive revision. That's the surest way of doing the intensive revision. You go, you take the old roll, you go read out the names, and people will say, and if you have it videographed, nobody can raise any objection as to what had happened. If 4 people say, no, such a person doesn't live here, you cross his name out unless somebody disputes that, etc. Therefore, my lord, that's the best way, and that is provided in their manual. And that's what I respectfully submit, my lord. This is something which is happening for the first time in this country. It has never happened after the first roll was prepared in 1950 or 1951. And it is being done in an unseemly hurry. And therefore, my lord, even if it is assumed that this exercise is permissible, this kind of de novo preparation of electoral roll in this manner by requiring everybody to furnish enumeration forms and documents, etc., even then, my lord, it has to be done at least transparently, at least by following some rules, not totally arbitrarily, by saying, giving them an arbitrary power to decide citizenship, etc. That can't be done, in my respectful submission. I am very grateful to your lord.
Yes, ma'am.
Please. My lord, since we are in rejoinder, I will confine my arguments to strictly the law. May I just hand over the written submissions because I will be free. Just give to the others. My lords, much has been made as to who are the...
I have given my written submissions to your lordship. That must be there. The written submissions in the joint.
My lords, much was made about who the petitioners are. The petitioners who I represent are citizens, ordinary citizens of Bihar and voters of Bihar who stand before you. My lords, if you look at the legislative history of the RP Act, it is very instructive because it shows what is the statutory scheme starting from 1950 down to 1966. And it contradicts the reading of the statutory scheme on behalf of the ECI. Section 21(1), as it exists today, came in 1955, after the first elections. The first election of 1951, it was section 23 and 25, now it is section 21(1). In 1966, the only amendment made was, unless otherwise considered fit. I will come to that aspect in a moment. Why I'm pointing this out is because it was said repeatedly that section 21(1) belongs to the first elections. This was an argument that was canvassed. It has no role any longer. Section 21(1) actually gives legal effect to the preparation and the publication. The final role is the role that is published. The rule under which it is published is Rule 22(2). My lords will then see in paragraph 1820 of the counter affidavit, dated 21st July 2025, filed by the Election Commission. They expressly state that the present special intensive revision results in the preparation of the electoral roll afresh, as it is a de novo exercise. A de novo exercise or an afresh preparation of the electoral roll takes place in conjunction with Rule 25(2), which my lords had pointed out right at the beginning. Rule 25(2) remains in play every time an intensive revision of rolls takes place. And Rule 25(2) puts together how it is to be done and the rules applicable from Rule 4 to Rule 23. Even if a plain reading of 25(2), this would be clear. The exception that is sought to be carved of 21(2) I would come to in a minute. If we can just take 21(3) first. The best case made out is that this exercise is taking place under section 21(3) and it is an unshackled from any rule, any law. And that is why this is an exercise in the nature of a legislative character. Section 21(3) creates an exception, and this is since 1956. It creates an exception only to 21(2), to the periodicity, to the timing, to the clockwork frequency with which the revision of roles has to take place, either before elections or annually, because of the binding directive of shall, unless otherwise. My lords, it's a admitted fact that since 2003, there hasn't been an SIR. The reason why they are not falling foul of 21(2) is because 21(2) gives the flexibility. You need not. So unless otherwise directed is to not conduct the SIR rather than conduct it as per the timing and the frequency noted in the statute. And that is what 21(3) says, you need not, as you may deem fit. I'm not going into any constituency, all constituency, etc. The other aspect when it says of 21(3), where it says in such manner, to conduct what? Are you going to conduct a summary revision or are you going to conduct an intensive revision? These are the two forms of revision that the law recognizes and for which there is the detailing in the rules. Rule 25 deals with both summary and intensive. Intensive is under 25(2) of the rules. It does not unshackle them from the rule. That rule continues to operate. The unshackling is from the timing and the frequency with which you have to do it. It nowhere unshackles from Rule 25(2). They themselves say they are conducting it afresh. If you are conducting it afresh, Rule 4 to 23 will bind you, and that is the manner in which it is required to be conducted. The next aspect of which has already been dealt with, I will mention it in passing, of unless otherwise directed under section 21(2), which I have just mentioned, to escape the rigor of shall. I will just also point out, actually, in the written submissions filed by senior counsel on behalf of ECI, Mr. Pat Joshi, in para 17, it is conceded that this phrase, unless otherwise directed, only provides the ECI with power to dispense with revision otherwise mandated by section 21(2). This is in the written submissions filed on behalf of the ECI. My lords will then come to the plenary power under 324, again something that has been discussed. I will only point out two additional facts. This is a field occupied by law, occupied by RPA, occupied by rules made by Parliament. An argument was canvassed that AC Joes can be distinguished and does not conform to the Constitution bench of Mohinder Singh Gill. AC Joes being a free judgment. AC Joes in paras 16 to 25 specifically deals with the ratio of MS Gill, quotes MS Gill and reaffirms the principle that the election authority will operate within the field of enacted statutes and rules. There is no inconsistency between AC Joes and Mohinder Singh Gill. AC Joes then citing the ratio, reaffirming the ratio of Mohinder Singh Gill, goes ahead and says there is a check on this plenary power and there is good reason for the check on the plenary power, and paras 16 to 25 deal with this. So to say that this is legislative in character and Article 324 gives us that is not the settled law both by a constitution bench and by a three-judge bench. My lords, then Lal Babu Hussain, which has been dealt with at length, only to say there is no differential probative value attached to any enrollment and an SIR enrollment. That is not what Lal Babu Hussain states at all. In fact, it goes on to say in para 13 that these persons were voters in previous election and hence it would ordinarily appear that their cases were verified before their names were entered in the electoral rolls. That is because it may be presumed that official acts performed under the provisions of the 1950 Act or the 1960 rules were regularly done. So there is actually an observation to the contrary in Lal Babu Hussain. My lords, before I conclude, just one asset should give me those copies. May I just, for convenience, hand over the notification which my lords are very familiar with by now. And my lords will see the last clause of this text. This is the 24th June 2025, the SIR notification for Bihar. My lords would just glance at the last clause, clause 15. This will be the last page.
Yeah, that SIR order.
This is the SIR. This is Annexure A, the notification order for Bihar. My lords would glance at clause 15.
Yes, further.
Further, in case of application for registration as a new elector or for shifting from outside the state of Bihar, it is also directed that henceforth, my lords may just mark this, henceforth, along with Form 6, Form 8 and additional declaration form Annexure D shall also be required to be filled by the applicant to support the declaration made therein. So this is not an exercise that is happening now to create one SIR. And that role, electoral role for Bihar now exists and will thereafter be the electoral role valid unless summary, division, amendments, and other intensive revision. This says henceforth, it has amended the law by bringing in an Annexure D, and therefore the repeated emphasis that this is an exercise that is legislative in character without being able to anchor that power. In Article 324, in judgments of this court, this Annexure D is where those 11 documents come in. And they are now required. So even today, the SIR in Bihar is over. Somebody turns 18 all the time. I will fill a Form 6. But when I fill a Form 6, I will now be, or I'm shifting out, or I'm shifting into Bihar. Form 6 or Form 8. I will be required to now fill the declaration form, and therefore I would be restricted to these 11 documents, not 12 documents, 11 documents. That 12th document was accepted during the currency of this pendency of the SIR. So there is an amendment that has taken place by this notification. Under what intensive revision does ECI have the power to amend the law and bring this? This is not only for one time, it is forever, and this is now traveling across the country. The October 2025 notification has taken it to Tamil Nadu, UP, Bengal, etc. Therefore, it is my respectful submission that this is a statutory amendment that the ECI has done in the garb of an executive notification and order. And where do they get the power to do this? They have not been able to place on record any such material which gives them this power, except to characterize it as a legislative exercise. My lords, I will conclude with this, and my written submissions are already on record. I am very grateful.
Thank you. Thank you. Yes, Mr. Sudha.
Only two very short points of rejoinder. Sorry. Just two short points of rejoinder, one on citizenship and one on section 21. Before Lordship even come to the notice. Citizenship, my lord, is an umbrella right. From that flows a bunch of rights, including right to vote. Plus, there is no difficulty. Different agencies have to identify citizenship as part of that process. Election Commission, my lord, is also required in that respect because the person is required to be a citizen of India. Now, my lords, what is the mechanism which the constitution, which the law envisages in terms of authoritative determination of citizenship? Your lordships will just first have section 14 of the Citizenship Act, just for a moment, and then I straight away go into the note. Section 14 of the Citizenship Act 1955.
Yeah.
Section 14 says issue of national identity cards. Lord Justice Bakshi has section 14A, I'm sorry, 14 capital A. 14 capital A. issue of national identity cards.
274.
Yes, the central government may compulsory register every citizen of India and issue national identity card to him. So this is a power, it's empowerment, it's not mandatory, but the central government has the power to identify every citizen and issue a national identity card. Procedure to be, kindly have subclause 5, the procedure to be followed in compulsory registration of the citizens of India shall be as may be prescribed. So that if the exercise is undertaken, the central government will come up with rules under this section which will carry out that process. Now that process has not been carried out by the government of India. It's only an empowering provision, it's up to the government. It says may. Well, in the absence of that register of citizen, how does any agency, including the Election Commission, which has to possibly test citizenship as a requirement, go about doing it? That's one of the questions which arises. Well, we are grateful to Mr. Hansaria yesterday. He gave a list of bunch of acts where there is a requirement to test citizenship.
Yes.
Because at the bottom of that, I have in my note, at the bottom of it, actually reproduced is, we examined. Now your lordships will have, for instance, Advocates Act, section 24, an advocate has to be a citizen of India. Similarly, Patents Act. Then there is Trademarks Act, etc., etc. In all of them we examine, the test is self-declaration in effect. In some cases attached with proof of residence or proof of date of birth. In none of them, there is any independent verification mechanism to go about determining how are you a citizen. There is a standard test, which I have put now in my para 2, which is date of birth, ordinary residence, self-declaration. That is exactly the test, which section 19 envisages, which is place of residence, date of birth, and in the form 6, self-declare that I'm a citizen of India. Once that is there, citizenship is presumed. Now, imagine a situation where if as an advocate, Bar Council tomorrow sends me a notice, I want to test whether you're a citizen of India. What test does Bar Council of India follow and the Advocates Act? Will they have their own test? Say I'm a voter as well, the Election Commission will ask me that question. There is a possibility both of them will take different views. Patent agent can also ask me when I'm filing for a patent because only a citizen can file. So, different agencies cannot be coming to their own determinations. The test is constitutionally envisaged, statutorily laid, which is proof of residence, date of birth, and self-declaration. If beyond that you have to go, absent a citizenship register, you have to make a determination. That is what section 16 is, to knock me out of the list. Well, otherwise, every agency can come up with it because there are requirements everywhere. Your lordships have vast judicial experience. I don't know if your lordships will have ever come across an order of a bar council determining citizenship of an advocate. Or the trademark agent, because there's a requirement there as well of determining citizenship. So just because the requirement is there doesn't mean they have a right. The statute itself says once you declare these two things, you are assumed to be a citizen unless declared otherwise. It's a very practical stance taken in the statute of section 16 and 19. Well, that's my respectful submission. Now, one aspect is Passport Act. I have put it serial number 9. We examined, thanks to Mr. Hansaria after he placed the material. Even for passport, kindly have page 5 of my note. Even for passport, which is a document of citizenship, I travel in the name of the President of India as a citizen of India abroad. That's the opening words of the passport, as the lordships know. There also the requirement is only dual. Look at the list of documents at page 5. As a proof of address, water bill, telephone, electricity, income tax assessment, etc. And as a proof of date of birth over the page, these are birth certificate, PAN card, driving license, etc. So even for a citizenship document, which is the passport, the requirement is only those two along with a self-declaration. Because how does Election Commission now determine citizenship? But this is the standard rule followed across the board even for passport. That's my first submission, and therefore that formulation is there. Finally, insofar as the Election Commission did not answer one very important question, Mr. Dwivedi said that the actual numbers do not matter of how many non-citizens we found in Bihar. The Bihar process is over. Well, I respectfully submit the actual numbers do matter because the Election Commission is actually finding a solution for a problem which does not exist. If it's only 10 or 20 people, do you scan a population of 8.9 crores? The number should have been given to the court. The court, in fact, I understand, had at one point asked for it. What are the numbers of non-citizens that you have found in Bihar? Now, the number should have been given. If it's 50, 100, you scan a population of 8-9 crores to find 50. So, they are effectively giving a solution for a problem which does not necessarily exist, at least in every state. That's my respectful submission. Absent those numbers, why should they be doing this disproportionate exercise? So that's on citizenship. Plus the second submission I have on section 21. On that, my lords will have the last part of my note, which is at page 4. Well, Election Commission just on 21.3 and 21.2. On 21.3, Election Commission says, read the words constituency broadly. Any constituency will also include all constituencies. But of course, it's possible for a court to take a textual view on 21.3. It's possible for the court to take a broad, expansive view on 21.3. But what I would submit is whatever view your lordships take on 21, textual or a broad, will be consistent between 21.2 and 21.3. It can't be that in 21.2 Election Commission says the words prescribed manner refer to the rules and therefore you stick to the rules, you stick to the word in 21.2 as a prescribed manner, and in 21.3 as it thinks fit will be a very broad meaning. Why I'm saying that is, if my lords, your lordships give a meaning to any constituency, meaning all constituency, let's assume it, then as it thinks fit will have to be given a narrow meaning, because otherwise, my lords, what will happen is, this is an exceptional power, textually at least, exceptional power given to Election Commission, in which case they can go away from all the rules. But if your lordships give 21.3 a broad meaning, then obviously the full pay of the rules has to come. Otherwise, what happens? A parallel mechanism completely. It's a parallel mechanism, dehoves the rules. Already we have 2 petitions before this court which are saying that you should do SIR before every election. Correct? So there is today a situation where certain parties are saying you do it all the time. Why do you need even the normal mechanism? Do SIR only. If that's the parallel mechanism, this rule 4 to 25 protection is out. The Election Commission can only do SIR, dehoves the rules. So if your lordships were to give expansive meaning to 21.3, consequently the rules will have to come into play. Otherwise, a parallel power without check, which will completely defer the protections in the middle. That's my respectful submission. I'm grateful.
Just very briefly, I'll also just hand over the submissions. Just pass the submission. Just few short points. I've annexed my earlier submission also, which I filed, and just the supplementary ones. One of the first point would be, which already now dealt with by Mr. Sibal, lack of reasoning, no material which is there. And Mano, just to buttress that point a little bit more, Mano, this I had already dealt with in my point B at page 9. My lord may just make a note, my lord may not read that, of the present written submission, because I've included both my earlier one and the present one. So point B at page 9, point 9 and 10 of this present written submission, my lords, as that no reasons has been given. There should have been some material. Now, my lords, what is also very important here I want to supplement is PDF page 403 and 404 of volume 4A. Why the lack of reasoning becomes much more disturbing is because of this press release which the Election Commission had given earlier. My lords may just make a note of that page, PDF page 403 and 404 of volume 4A, in which it says, as per the directions, and this was sometime in, my lords, before this whole SIR exercise was carried out, the summary revision had been carried out. It says, as per the directions of the Election Commission of India on 7/1/2025, the final publication role for the state of Bihar has been carried out for all 243 assembly constituencies. In this final publication of electoral rolls, total number of electors is so-and-so. In the draft publication, gender ratio was 910, which has now increased to 914. There has been a consistent improvement in gender ratio in Bihar's election. In the draft publication, so-and-so number of names have been added, so-and-so have been deleted. Thus, the net increase in the number of electors during the specified period is so-and-so. The net increase, etc. They give all those details. Then, my lord, in page 2 at PDF 404, they say as part of summary revision, special campaign days were organized for facilitating active participation. These campaigns were conducted at all polling stations in all constituencies, and then they talk about interacting with the parties, etc. So, my lords, the substantive exercise is carried out according to their own press release. Therefore, the lack of material becomes even more disturbing, because if this substantive process has been carried out, and if they felt that this substantive process was not proper, that is not even a reason. That is not even a part of their material. The only reason they give are those vague reasons, my lord, without any material on record. So, my lord, that's the first point I wanted to emphasize. The second point is that where was the need for a hurry? Well, if one looks at 21.3, well, I may just section 21.3, if I may just take my notes there. Yes, section 21.3. And it says, notwithstanding, Ms. Brinda Gobar has already dealt with, that the non-obstante clauses pay the timing, that it need not be as per the qualifying date. You can do it whenever. So the fetter of time is completely out. You can do a special exercise at any time you want and for whatever period. For that, I'd like to concentrate on the proviso. 21.3 proviso provides, provided that subject to the other provisions of this act, the electoral roll for the constituency as in force at the time of the issue of any such direction shall continue to be in force until the completion of the special revision. So this proviso makes it incumbent that if you need a special exercise to be carried out, there is no time limit, there is no restraint. The earlier one stands. I've shown the publication of EC itself saying that they had done a summary revision. My Lord's query had come. Suppose there are deletions, etc. Well, if all that had been dealt with in the summary revision, then why this tearing hurry? And look at the cost which it is causing, my Lord. I don't need to replicate it. My Lord is well aware of it. Day in and day out, all kinds of summary SIR petitions are being filed. So this highlights that arbitrariness which is there. Then, my Lords, may I just point out to the revision, the type of revision. This comes to the scope of discretion under 21.3. Now, noteworthily, the wording used by the Election Commission is special intensive revision. So the moment they incorporate intensive into that, suppose it was a special revision, and I can understand they can argue something about, say, Assam, for example, it's happening in Assam, there's a special revision. When you bring in special intensive revision, then automatically you incorporate the prescription. So your discretion in the manner in which you have to carry out the exercise first has to conform with the statutory prescription of an intensive revision as defined under the Act. That you have to cover. In addition, if you feel there is something special to be added, which is not covered by the rules, or which the rules don't take care of, that's when the special will come. So your discretion cannot be an unguided discretion, very fairly accepted also by the Election Commission. What is the extent of discretion we have to look at? And we have to draw our thing from the reading of the two provisions, but more importantly, EC itself saying that this is a special intensive revision. The moment you bring in intensive, that has to be there. And then they have to point out that as per these existing rules, so and so, so and so, these are the problems which can't be taken care of. It's not that migrations didn't take place earlier. It's not that there were earlier no problems like this. These have been taken care of. For any reason, if it is not, that material should have come on record. Then, my Lords, may finally come to one last point, and that is that they again, and that's in my point 9 of my written submission, which I have already dealt with and which they did not answer. One of that chart which was given by Mr. Maninder Singh, that 21.3 and then there's an arrow which takes you to 324. Well, 324 is a residuary provision. What is covered by the statute, the 324 is not going to be going into that. That is covered by the statute. If you want to look at something else which is separately, that's separate. Well, that's all. Those are my questions.
Thank you, sir.
Yes.
Thank you. Yes, Mr. Fashion.
May please, madam. Lordship, the point has been well made that the way the Election Commission is interpreting section 21(3), it's creating a parallel process. So the Election Commission has a choice whether to go for the process which is prescribed or to choose not to follow the process which is prescribed. And what Mr. Prashanto was just saying, that insofar as the residuary power is concerned, the residuary power necessarily has to be after what is occupied by the specified power is already accounted for. So this, the question, he wishes to conclude. So that's why I've taken the liberty of going before him. The residuary power in section 21 subclause 3 is being read.
We will request Mr. Raju to sum up everything.
That's right.
Oldest should be the last. Oldest should be the last.
But Lordship, pinch hitting usually happens in the end. Lordship, section 21 subclause 3 is therefore the residuary power, and that's why in my humble submission it refers to constituency or a part of a constituency, because the intention is to deal with peculiarities and particularities that may arise in a particular constituency or even a particular part of a particular constituency, which cannot be dealt with by the general or have not been dealt with by the general rules which have been prescribed. And to say that that power is being interpreted in such a manner that these peculiarities and particularities have arisen throughout India, and therefore the process which is prescribed in 21(2) no longer needs to be followed, is not an interpretation that is tenable. Also, the carte blanche that it gives the Election Commission, in my opening arguments, I had made the submission that why 2003 and the selection of 2003 as the base year is completely arbitrary. So now, because this is the kind of wide carte blanche power that Election Commission is claiming for itself, in what manner does it exercise it is actually evident in the selection of 2003 as the base year. And Lordship, I'm just reading from the submissions of Mr. Dwivedi. It was thus decided to use 2003 rolls as probative evidence of eligibility, as individuals featuring on the 2003 electoral rolls would have necessarily substantiated their date of birth, place of birth, and ordinary residence in the SI of 2003 or in the intensive revisions that preceded that exercise. As if to suggest that those persons who came into the electoral roll after 2003 were without substantiating their date of birth, their place of birth, and their ordinary residence, even though the exercises were conducted by the Election Commission itself. And Lordship, so therefore my original argument that a revision is intensive or general or summary, not to an individual. An individual is still required to meet the same standard for entering the electoral roll. Whether it is in 2003 or thereafter, any of the summary revisions, the standard to which an individual is subject, which is rules 8 to 21, all of those are still applicable even if an individual is being brought into the electoral roll. Therefore, I am required to substantiate with the same degree of probity my date of birth, my place of birth, and my ordinary residence. Now it is being suggested that as if in the 2003 rolls this was substantiated and afterwards it was not, because it is an exercise, again I repeat, is not intensive or summary to an individual. It is intensive or summary to the entire state or the entire country, that if only a part of the state or a part of the constituency has been looked at, or an individual has been brought in, then it may not have been intensive to the entire country. But to say that in each individual's case, he would have entered the role without substantiation after 2003 is not something which is merited, and also contrary to principles of the Evidence Act, that official acts have to be presumed to be done officially. Now, Lordship, we filed an RTI application seeking to understand what was so special about 2003 that 2003 was selected as the base year and no year subsequent to 2003 was good enough. And I'm just reading the RTI query, which is very short, but any and all press releases, orders, notifications and directions issued by the Election Commission of India and or the CEO Bihar specifying documents required to be submitted by intending voters for inclusion in the electoral roll as part of the intensive revision of 2003 in the state of Bihar, through which the electoral roll of the state was updated, is the RTI query. The response we received to this, Lordship, is please refer to Election Commission's SIR order of 24 June 2025, which is self-explanatory, and a link to the order is attached. So, Lordship, there is not just is this power being exercised without reference to what is prescribed, but there is also a condescension on indicating why we exercise the power in the manner that we exercise it, or what was so special. Lordship, the transparency also seems to have completely gone away. In fact, Lordship will remember that when I had pointed this out in course of the interim orders, Lordship had asked the Election Commission place the 2003 guidelines on record. Lordship, that was never brought on record, and it was Mr. Prashant Bhushan for the ADR who had to finally bring it on record. And oddly, Lordship, even when addressing that, the Election Commission says the guide and refers to the pages of Mr. Prashant Bhushan's affidavit by which it was brought on record. The Election Commission till date did not feel it necessary to bring before this honorable court the basis on which 2003 exercise was conducted, which is the bedrock for justifying why 2003 is being selected as the base year. So, Lordship, therefore, the ambit of the power is excessive, and the exercise of that power is completely arbitrary and completely non-transparent. Lordship, and once Mr. Prashant Bhushan placed the 2003 guidelines on record, Lordship, 2 or 3 lines from that 2003 guidelines I wish to point out to indicate the vast divergence from even the 2003 guidelines that is now coming in. And Lordship, this is relevant because the Election Commission in its response simply says there is no obligation on the ECI to conduct every special revision in an identical manner. The degree of intensity with which the special revision is conducted is bound to vary. So, Lordship, therefore, they are washing their hands even of their own past precedents, etc. And 2003 guidelines, the reason why they wish to wash their hands of it is because I'm reading paragraph 32 of the 2003 guidelines, which says it is clarified that it is not the job of the enumerator to determine the citizenship of an individual. However, they have the power and the responsibility to exclude any person on the basis of the qualification for registration regarding age or ordinary residence. And there is a special section on that, which is paragraph 63, which is verification in areas having substantial presence of foreign nationals. And that, Lordship, in my humble submission, is the kind of situation which is contemplated where a constituency or a part of a constituency is mentioned in 21 subclause 3, because there may be areas, for instance, having significant presence of foreign nationals where greater scrutiny is required. Lordship, in 2003, while dealing with areas and parts of constituencies where there is more presence of foreign nationals and greater scrutiny is required, even there, Lordship, it says that at the time of house-to-house verification in these areas, the enumerators shall include the names of only such new persons who belong to the same household whose names is already registered on the list, or in cases where the concerned person is in possession of an EPIC number issued either for that constituency or any other constituency. The enumerator shall, in respect of all other persons who wish to be enumerated for the first time, supply a form as prescribed pro forma so-and-so for inclusion. Therefore, Lordship, even in areas where there is greater presence of foreign nationals, which are being separately dealt with in the 2003 intensive exercise, it is said that if you are already on the roll or your family member is already on the roll, then you will be included in the house-to-house enumeration. It is only when it is a fresh inclusion that there will be a separate process, which is a form which is prescribed. And even then it says in this process, which is now what remains, new persons in areas where foreign nationals have a higher presence, in each, a report will be submitted to the electoral registration officer in each individual case. In no case, any such agency other than the concerned electoral registration officer shall summon the person under verification to the police station or their offices, or insist for production of documents only of a specified nature. Therefore, Lordship, even in situations where you are dealing with parts of constituencies where there is greater presence of foreign nationals because illegal immigration is being cited as the reason, this is the safeguard that was provided, not being placed before this honorable court, and even that is being washed. They are seeking to wash their hands off, saying 21(3) is a carte blanche power, and we are bound by nothing, including what is the Parliament has prescribed, what the rules prescribed, what we have ourselves prescribed earlier.
Thank you.
Lordship, that is an acceptable interpretation in my humble grateful.
Yes.
Please, my lords. My lords, there was another question that fell from my Lord Justice Bakshi yesterday, which was, how is an ERO who's sitting in a case of disqualification or objection under Form 7 to proceed with the papers that she has in front of her? And I ask myself this question: what is the difference between determination of citizenship and something more preliminary? The other side has called it verification of citizenship. So in proceeding, there has to be a material difference between verification of citizenship and determination of citizenship. And what is that material difference? What is the lower threshold? And if I may invite lordships to just read one paragraph with me, that's volume 4A, page 1065. If lordships will just have page 1065.
Please read it.
May I just read it then?
Yes, please.
It's the Election Commission's own affidavit that was submitted before the Jharkhand High Court in the year 22. The question before the High Court was that this Honorable Court has directed a response from the respondent being the Election Commission, as to how effective measures to be taken to deal with the issue that is illegal infiltration in Jharkhand and other correlated issues. Their response, my lords: they say that if a claim is made disputing an individual's citizenship, the ERO is required to be cautious if questions have been raised on the documents as specified under paragraph 4F above. The ERO then may approach the relevant issues. The ERO may then approach the relevant issuing government authority to authenticate the documents or may refer the matter to the Ministry of Home Affairs, as the case may be. Therefore, the ERO may initiate an inquiry if credible allegations or other valid reasons arise. In the absence of any credible allegation and the existence of legitimate government-issued documents, the ERO's authority to question or initiate inquiry into an individual's citizenship becomes restricted. Therefore, a person is deemed eligible if he is able to submit the documentary evidence in support of his eligibility as prescribed in the RPA, and at the same time is not disqualified on the grounds provided in RPA. Further, should there be any reason to suspect that any of the certificates produced by the applicant is bogus or issued without due care, the ERO is instructed, as per paragraph 7.4.1 of chapter 7 of the manual, to report to the authorities that issued that certificate. This is another effective mechanism prescribed for dealing with the issue of illegal migration. So, Lordship, he has to then refer back to the issuing authority and ask for an authentication or some kind of a response. This is therefore mere verification. Even the preliminary striking out is not envisaged as per their own response to the High Court. This is a much lesser threshold of a verification process. There's one last point, Lordship, which is extraneous but also not to the current case, which is that the determination of citizenship is not only a matter of law. Very often there is a political discourse, there's a public discourse accompanying it, which frames the entire issue. Even today, there are sitting chief ministers, there are high officials who are calling out for an abuse of process during the SIR. Lordships are in season of the matter, and Lordships must be also conscious to the kind of abuse of process that is being almost invited by high officials. I'm grateful.
Thank you.
One extra. Just one page. Submission. Two or three short points. First is arbitrariness because no relevant or valid reasons connected with any legitimate state aim are set out to justify a special revision under 21(3). Keeping in mind, minutes, what I had said in my principal submission, that apart from being a constitutional right, it touches three other fundamental rights, though not a fundamental right by itself. That is 14, 19(1)(a) and 21. Therefore, there have to be special reasons made out. And minutes, we have tried to show that this has just been a mechanical recitation which has been applied across the board to 12 states. At the least, minutes, the file ought to be seen by your lordships to show that they applied their mind. However high an authority they may be, however sui generis their power may be, they, like every other constitutional organ, have a duty to apply their mind, and that application of mind is not apparent on a reading of the order. It can't be inferred merely by a statement of reasons, and therefore there is not enough to satisfy your lordships unless your lordships are to at least see what were the deliberations which led to this, minutes. Also, minutes, when under 21(2), in any case, this exercise has to go on before every election. So all these reasons which keep happening in human affairs, migration, etc., that is why before every election to Parliament or State Assembly or even a by-election, if it is being done generally, then what is that surprise element which was spoken of in Mohinder Singh Gill? What was that special reason that has not been demonstrated to your lordship so far? And minutes, plenary powers under Article 324 do not provide for unfettered discretion. And the exercise of this power is still subject to judicial review. And minutes, my Lord Justice Bagchi asked a question. I don't think a satisfactory reply has come from the other side. What gives you the power to drop requirements from 6? For instance, minutes, the driver's license or minutes, what is the other card? The PAN card. That answer has not come to your lordship's minutes. To deviate from a set procedure, from a rule, in the exercise of this so-called plenary power, they have not satisfied your lordships in my respectful submission. Second, minutes, lack of reasons is demonstrated in the choice of states, minutes. 24(6) at least said Bihar is imminent, we are starting from here. Now that is what is being used for a variety of states. Now minutes, among the 12 states included, one is Chhattisgarh, which goes to the polls in 2028 December. Then what is the urgency? And what is the reason for excluding other states which go to the polls in 2028? There is no demonstrable reason at all, minutes. And we have put a table, minutes, indicating which states go to the polls when. Then, minutes, paragraph 6, minutes, in the first page, categorization of a certain state act to have the character of its being legislative does not make it immune from attack on the ground of arbitrariness. Assuming that it is legislative as was sought to be argued, I would submit you can't call it legislative. It doesn't emanate in any sense from an elected legislature. You may call it a sui generis constitutional power, but it is certainly not legislative in the sense that if the legislature states a certain set of facts, then it must be taken as a given. That can't apply, minutes, to a constitutional body, however high, which is not elected. Now, my last submission is this, minutes. The thrust of the Election Commission's argument, the opening argument was that in fulfillment of this charter of universal adult franchise, which is also a privilege given to citizens, and so it is an essential part of the duty of the Election Commission to see that this valuable constitutional right is exercised only by citizens. That's how I understood their argument, minutes. And let us accept that at face value. But going with that plenary power, also every power is coupled with a duty. And so if you claim that power for yourself, and maybe legitimately, there is a corresponding duty. And what is that duty? Let me spell that out, and that is my last submission, minutes. Whether to vote or not to vote is the choice of a citizen. He may not go to the polling booth, or he may do nota, which right has been given by your lordships. But the Election Commission has a duty to prepare a full electoral roll. It has a duty to see that all eligible persons are included there. It cannot say, we can't help it if someone didn't fill in this form. No. If this is your high constitutional role, it is also your proactive constitutional role to see that everyone eligible comes on that roll. And the entire methodology of this exercise has not been that of a facilitator. It is, in fact, by creating these roadblocks, by dropping certain identity documents, etc., then I would go so far as to submit that, contrary to its high role, minutes, it has abdicated its duty in ensuring that every eligible Indian citizen comes on the roll. These are my submissions, minutes. I am grateful. Great.
Sophie and Madam Singh, do you want to add anything? Only you two are left in the out of the list. Well, thank you very much. Thank you all. Very grateful.
Mr. Dwivedi wanted to get connected from minute.
If any additional written submission, any notice to be given,
Yeah, Dwivedi wanted to say, my lord, he was getting connected, that new point which are there, they may be permitted.
All of it.
Grateful.
Grateful.